Yeah, can we get going?
Yeah. Just have the board members chatting, so we should just get
Good morning, everyone. We're calling the meeting to order. First item is we want to welcome a new board member today, Jackie Sherman. Welcome. Just a little background. Jackie's the Chief Legal and Administrative Officer for JCCA, which is a large child welfare and family support organization which provides comprehensive care to thousands of children, young people, and their families who come from New York's diverse communities. Prior to JCCA, Ms. Sherman was Associate Commissioner for Planning, Policy, and Performance at the city's Administration for Children's Services. Ms. Sherman was nominated to the board by the presiding justices of the Appellate Division of the Supreme Court, First and Second Departments, and was appointed by the mayor. She begins a 6-year term today. Welcome, Jackie, and we all look forward to working with you.
It's also my pleasure to report that the mayor has appointed Derek Cephas as the chair of the board officially. Chair Cephas has served as acting chair since January 2018, as vice chair since February 2015, and as a board member since October 2014. So the board members, the staff, and I are really thrilled about your appointment and the opportunity to continue to work with you. Thank you for your leadership. And just to make a note, member Jennifer Jones-Austin is joining us a bit late because of a travel conflict.
Thank you. So the first item on the agenda is to approve of the June 2008 board minutes. Is there a motion?
No move.
Is there a second?
Second.
Any comments, questions, additions to the minutes? Great. Thank you. All in favor?
Aye.
Aye. Okay, thank you. Minutes carry. Next item on the agenda, we will hear from the Correctional Health Services update on the substance use treatment. I'm going to now invite Dr. Jonathan Giftos to address the board. Dr. Giftos is a clinical director of substance use treatment for Correctional Health Services, where he oversees diversion, harm reduction, treatment, and reentry services for incarcerated patients with substance use disorders. The city has long been a leader and a model for its substance use treatment in the jails. They have the oldest jail-based methadone program in the country, the Key Extended Entry Program, or KEEP. In addition, since the early 1900s, the board's minimum standards have required observation and treatment to prevent complications resulting from intoxication, withdrawal, and associated conditions. They also require CHS to make available education or referral services related to substance abuse. CHS continues to lead in its substance use treatment program. We'll now hear from Dr. Giftos to provide an update on this work. Dr. Giftos, welcome.
Thank you very much. All right, so My name's John Giftos, and I'm the Clinical Director of Substance Use Treatment and the Medical Director of the Opioid Treatment Program. I also see patients clinically in the jail system, and I look forward to talking to you today about our work caring for people who use drugs. I'm going to cover three main things today. I'm going to provide a brief review of the prevalence of drug use and addiction among incarcerated patients in New York City. I'm going to review the CHS core services pre-2017 insofar as they relate to people with a substance use disorder, and I'm going to describe some recent expansion efforts that we've been undertaking. So as you might expect, people in the jail system drug use is very common among people in the jail system. And when drug use rises to a clinically significant level, it's generally considered, it's called a substance use disorder. And that's marked by escalating use over time, a loss of control, continued use despite negative consequences, a buildup of tolerance, and a loss and withdrawal when you stop using. And within the New York City jail system, about half of all patients admitted have clinical evidence of a substance use disorder. About 20% of patients have a cocaine use disorder, almost 20% have an opioid use disorder or using heroin, and a similar proportion with an alcohol use disorder. But within facilities where we have a higher prevalence of mental health treatment and drug treatment services, the prevalence of people with a substance use disorder is much higher. So in AMKC, for example, the largest facility, about 70% of patients have a substance use disorder, and almost half of all patients at AMKC have an opioid use disorder. And opioid use disorder is just really a particularly important substance use disorder because it's associated with high post-release mortality. So patients that enter into correctional settings with an opioid use disorder are taken off of opioids, and in many settings they lose their tolerance. When they go back to the community, if they return to use, they're really high-risk exposure for a fatal overdose. So opioid use disorder in correctional settings is a really important diagnosis to make and treat. And among our frequently incarcerated patients, the quote-unquote hotspotters population, we see a very high prevalence of substance use disorders, almost everybody, and a slightly different profile with a higher prevalence of cocaine use disorder, or in these cases, many of them are using crack cocaine. Harms of substance use for people include many things, including overdose death, withdrawal symptoms when people enter into the jail, infections from sharing injection equipment, social isolation, which is a real destabilizing effect of drug use for many people, acquisitive crime when their tolerance gets really high and they have to steal or sell drugs in order to pay for their drug use, and then incarcerations of frequent exposure. And the goal of our service is to really work to reduce these harms for people as they're passing through the jail. So we have CHS has some core services that have been in place for many years and that are very important and that constitute the kind of core efforts we have to reduce the harms of drug use for people that pass through. As you know, we perform a comprehensive medical intake for all new patients entering the jail system, during which we screen for a variety of substance use disorders, and we provide timely medical interventions and referrals immediately upon jail entry. We also provide supervised withdrawal with evidence-based treatments for people who have physical dependence on alcohol, benzos, like Xanax and Klonopin, and opioids. And this really reduces some of the misery of early incarceration that drives dangerous self-medicating behavior and violence. As Chair Cephas mentioned, we have the nation's oldest and largest jail-based opioid treatment program that provides methadone and buprenorphine maintenance to patients with an opioid use disorder, and I'll talk to you a little bit more about that. These treatments are especially important because they are associated with a marked reduction in post-release mortality for patients with an opioid use disorder. So whereas somebody with an opioid use disorder passing through a correctional setting has 129 times increased risk of dying on reentry, if they're exposed to methadone or buprenorphine maintenance, that risk is reduced by 75%. And so it's an incredibly important intervention to reduce post-release mortality. It's very rarely available in correctional settings across the United States. Of the 5,000 correctional facilities in the United States, fewer than 40 offer methadone or buprenorphine maintenance to patients with opioid addiction. So we really stand out as a unique in this regard. And we've had methadone and buprenorphine fully integrated for some time. In the last fiscal year, we treated almost 4,000 patients with methadone or buprenorphine maintenance, and those numbers have been steadily increasing. We also operate Road Not Taken, which is a jail-based diversion program that operates in 7 housing areas. And it provides a therapeutic community-like housing area with counselors on site, case management, and daily support groups for patients that seek out that type of engagement while incarcerated. As you know, we have a very robust mental health service. About 40% of patients with a substance use disorder are also falling with the mental health service. And in addition to ongoing mental health care, these patients are assigned a court liaison if they're in an MO unit, and all patients receive comprehensive reentry planning. Lastly, we've been distributing naloxone to families who are visiting loved ones in the jail system since 2014, and we've distributed over 7,000 naloxone kits. For those of you who don't know, naloxone is an opioid antidote. It reverses opioid overdose. And we did a follow-up study of about 300 family members that got these kits, and 50 of those family members had already used it to reverse an overdose. So it's evidence that it's getting into the hands of people who are likely to use it. I'm just going to talk about a few expansion efforts that have taken place in the last year. So the first expansion effort was really recognizing the life-saving benefit of methadone and buprenorphine maintenance, and in light of the ongoing opioid overdose crisis that's happened locally and nationally, we felt it important to expand access to methadone and buprenorphine for patients with an opioid use disorder. And this effort was driven by many factors, but one of them was a retrospective review of deaths of our own patients that had left the jail system. In 2011 and 2012, we looked at post-release mortality, and we saw that opioid overdose remained the #1 cause of death during the post-release period. And when we looked at 22 patients that died, 19 of those 22 were not treated with methadone or buprenorphine maintenance while they were in jail. So it reminded us of the fact that being off of treatment when you go back into the community is a risk factor for overdose, and we wanted to understand who these patients were and how we could better reach them. And what we learned was that we had a predictive model that was inaccurate. And what I mean by predictive model is that New York City offers these treatments, methadone and buprenorphine maintenance, but the state prison system cannot continue them. So for many years, we used arraignment charges as a predictor of whether somebody was going to go into the state system or not. And what we realized was that that wasn't a very accurate predictor of state transfer. Arraignment charges would often be pled down to misdemeanors. They'd still be considered in drug courts and treatment courts. So we did an analysis of our 2016 admissions with opioid addiction, about 8,200 patients, and we found that while 46% of them were eligible for methadone and buprenorphine because of misdemeanor charges, more than half of our patients had felony arraignment charges. Of that 54% with felony arraignment charges, only 28% went into the state system, and 72% were released back to the community. And that was a large population of people who were not being offered methadone or buprenorphine while in the jail system. So what we did was we partnered with the New York City court system, the Office of Court Administration, the various DA's offices in the various courts, and the Mayor's Office for Criminal Justice to improve communication around the likely criminal case outcome for patients with felony charges. And this allowed us to basically treat everybody that comes in the jail system with methadone or buprenorphine if interested, and we then coordinate closely with the court in the event that the patient's going to be sentenced to convicted of and sentenced to state time. And this allowed us over the last year to expand the number of people in our opioid treatment program from about 250 for many years on average to close to 1,000 now in the last year. And this has been a really important expansion effort for us. It's involved a lot of work on the nursing, pharmacy, medical, and our DOC collaborators. To provide these treatments to people in the jail system. And our enrollment of people who are eligible, who have opioid addiction when they come into jail, has steadily increased from 10% in 2016 to upwards of 60 or 70% of all patients. So we're making good progress towards making these treatments available to all who need them. In addition to, to providing methadone maintenance to people, we've also recognized that there are patients for whom methadone is not their preferred treatment. And so we've been working to expand buprenorphine access, which is a separate but well-studied medication for opioid addiction. And we've been increasing the number of buprenorphine inductions or initiation of this treatment over the last few years. So we're now doing about 250 new inductions of buprenorphine a year. The second expansion effort that we've undertaken is an effort to improve reentry services for people with a substance use disorder. This is a population that sometimes is churning through the jail system with high frequency. 58% of our patients with opioid addiction have 11 or more prior incarcerations. So it's a population where reentry planning is really important. And so additionally, the courts are evolving in their approach to patients with substance use disorders. Substance use disorders often related to people's arrest. The courts are increasingly open to treatment alternatives to incarceration for people with substance use disorders. And this poses opportunities and challenges for patients, but it means that community release often involves increasing levels of coordination with the court system. So with generous support from the city, we've been able to build out a service called SURE, which is Substance Use Reentry Enhancement, that seeks to extend the following key reentry services to patients with a likely substance use disorder not already served by our existing programs. And those core services are really the court services, so that we assign patients a court liaison that can work with the defense attorney to understand the likelihood of a treatment alternative or how the adjudication of the case may affect reentry planning. We now talk to everybody about overdose and overdose prevention, and we're training all patients in how to use naloxone to reverse an overdose. We also e-prescribe naloxone to patients to a community pharmacy when they leave. This staff does jail-based referrals to make sure people are connected to the right other treatment services that we provide, such as our opioid treatment program, the mental health service, and our therapeutic housing areas. These staff are doing Medicaid applications for people so that they have insurance when they leave, which is a prerequisite to entering into treatment when people leave the jail. You cannot enter into especially residential treatment if you don't have active Medicaid. And then transitional care services. This is really intense supervision of the person as they're leaving the jail, providing medications, outreach phone calls, and connection to services when they leave. And that last piece has just been is going to be supported now by this partnership we have with the Fortune Society, where our patients with substance use disorders are going to get additional transitional care services through Fortune. This is going to involve, in some cases, transportation. In other cases, it's going to involve telehealth visits to people while they're on the inside to build rapport so that they partner with Fortune when they leave, and other positive benefits. And this service is expanding. It started about a year ago, and we've been staffing it up, and we generally see about 750 patients a month. About 400 get a reentry plan, about 80 to 100 Medicaid applications. We're sending naloxone prescriptions to community pharmacies for patients when they leave, and we're calling people and their families the minute they're discharged to see if there's any outstanding needs that we can help with. And so this has been an evolving service that we're expanding and that we're proud of. So with that, I'll stop and I'll take any questions. Thank you.
Actually, just a comment. I think those who work, doctors who work in prison and jail, this is why we do the work. This is extraordinary. Growing that health and hospitals is put together, and I'm very, very proud to be on this board and to watch this happen. I think the only comment I would make, which is, you demonstrated, one of the key prosecutorial failures, not failures, deliberate incarceration of people, upcharging, and then having them sit there while they don't have to be there. And people are being punished for their drug use by having to spend time in jail. Then they get the charges knocked down. So this is just a tremendous effort, and I want to thank you and your colleagues for it.
Great. Your family should be proud of you. You're doing God's work. These people need help. I don't know the words to say beyond that. This is a crisis. What you're doing is wonderful. Thank you.
Being trained is proud of you.
Great.
Thanks very much. You're welcome back anytime, Mr.
Thank you.
Lewis. Yeah, you're good.
The board has 10 variance votes scheduled for today. 3 of those requests are from Correctional Health and 7 from the Department of Correction. The CHS requests are long-standing variances related to psychotropic medication schedules, tuberculosis screening, and the sharing of injury information with the Department of Correction. The DOC variance requests include variance renewals on the limited ability to waive the required 7-day respite from punitive segregation after 30 days, and a renewal that allows the Department to commingle 19 to 21-year-old young adults with adults. They additionally include 5 new variances related to the city's implementation of Raise the Age and the reopening of the Horizon Secure Detention Facility in October. We will begin the variance section of the meeting with public comment limited to these variance requests. Speakers, as usual, are limited to 3 minutes, and we'll have an additional public comment period at the end of the meeting on all other matters. The iPad will tell you and everyone else how much time you have left, and we'll get going.
Thank you, Martha. The first speaker is Julia Davis.
Good morning. I'm Julia Davis, and I'm the Director of Youth Justice and Child Welfare at Children's Defense Fund. We've submitted written comments before the board, and so I want to focus today my comments on the specialized secure detention. So first, it's important to note that you all are playing a very important role in implementation of Raise the Age. This is the law that establishes these specialized secure detention facilities that will be jointly operated by ACS and the department. And these are for the purpose of housing the adolescent offenders who will be prosecuted under the new law, as well as the removal of the 16 and 17-year-olds off of Rikers Island. And the purpose of all of this is really to treat young people like young people, to treat youth as youth. And I know several of the board members have been to see Horizon. I encourage all of you to do that, because your oversight of the facility will be critical to the success of Raise the Age in New York. I also want to ask the board to make a dedicated commitment to field staff that will be consistent observers of the facility and that have expertise in adolescent development, so that we can see a consistent review and engagement with the facility as it comes up and running. I think while in other settings other advocates have raised this, I want to raise it again, which is that we and others are very concerned about the Department of Corrections' role in this facility. And the fact that the department and the Administration for Children's Services will be working together is an important one. It is essential that the board observe and be engaged in this collaboration to make sure that the facility is not reproducing what we have on Rikers Island, but is creating what we need for young people in this special facility. The purpose here is really about engaging young people in a juvenile justice model, in something that engages young people in services and in support. And so with that in mind, I just want to spend the next couple of minutes walking through the variances. With regard to the single occupancy and the wet cell, for that to pass, the variance needs to engage with the fact that young people who are locked in need access to toilets. We need to have additional language that says that youth will have immediate access to toilets no longer than 5 minutes following the request. This is an area that's potentially ripe for abuse, for punitive actions, and we want to make sure that the department reports on its assurance that young people have access. With regard to the law library, it's also essential that if this variance passes, young people will have access, meaningful access to a legal coordinator. It's not clear exactly from the variance how that will function, and we want to make sure that there's language that requires young people to have access within 24 hours to that legal coordinator. And in addition, because the legal issues, I'll just finish here, are regarding their ongoing legal cases, but also the conditions of their confinement, we encourage the board to consider requiring that that legal coordinator be someone independent of the institution itself. So I'll leave it there. Thank you.
Thanks very much. We appreciate your comments. The next speaker
My name is Charlotte Pope. I'm also with the Children's Defense Fund of New York. My comments are going to focus on commingling. We remain opposed to the variance permitting commingling of young adults with older adults. In 2015, the board formally recognized through the minimum standards that young adults in the city's jails have unique needs that should be met through separate housing and age-appropriate programming and services. The purpose of dedicated young adult housing units was to create environments responsive to youth's needs and to make delivery of age-appropriate programming more feasible operationally. We understand that the department spends millions of dollars each year on programming for 16 to 21-year-olds and is contracted with dozens of providers to deliver these services. Despite this, the department continues to move away from housing young adults together. This June 2018 variance request shows that nearly all, or 86%, of the young adult population are currently housed in a commingled setting. Fewer than half of young adults were housed with older people in December of 2017. The department is going in the wrong direction. It is obvious that the current approach is not effective at ensuring young adults have meaningful access to programming and services. Existing variance conditions limit detailed program reporting data to GMDC, but the little information we do have about programming in commingled units shows very low levels of participation in what they refer to as classes. This confirms our fear that the department cannot effectively engage commingled young adults in the services that is allocated funding toward creating. In 2017, the department stated that young adults placed in commingled units in AMKC receive some elements of GMDC programming, but not the entire package, and that they would attempt to move young adults who express interest in attending school and other programming back to young adult-only settings in GMDC. Despite these described plans, there has been no evidence that the department is actually moving youth who show an interest in participation into young adult housing units. The department's own data shows that young adults are currently scattered over 9 different facilities on Rikers Island. We're concerned with the department's ability to provide services and programming in so many different settings and the potential for disruption that these moves create. In addition to our opposition to this variance, we request that the department provide details on the policies and practices that it uses for first determining and later following up on young adults' interest in school and programming. We further ask that the department be required to demonstrate its efforts to engage young adults in these activities and ensure services during this transition period. Thank you.
Thanks for that. The next speaker is Torri Lewis.
Hi, I'm Torri Lewis from the Legal Aid Society, and I'm speaking about the proposed variances for the specialized secure detention facilities. Raise the Age recognized that 16 and 17-year-olds must be provided a wholly different environment than the jails that they're in now, one that recognizes their particular needs. But simply moving to a new facility does not erase the department's past, nor does it ensure that the same problems are not repeated. Given this, and to help ensure that young people receive basic rights, we take the following positions, which we detailed in our written submission. For far too long, people in department custody have had access to toilets impeded and delayed by department staff, even for prolonged periods, simply as de facto punishment. This board has heard some of these appalling stories from young people in ESH, confined to restraint desks. To expect that these problems will not be replicated in the SSDs seems to us the height of folly and naivete. At the same time, we recognize that plumbing cannot be added by October 1st. Given this conundrum, we urge the board to deny the variance from single occupancy wet cells until clear operational guidelines are added, including a 5-minute time frame within which requests for bathroom access must be responded to, and until the board receives a plan from the department detailing how it will ensure these guidelines are actually implemented. Board staff needs to then monitor this variance extremely closely to determine whether it should be continued or ended. The board should deny the law library variance requested, at least in part. While we do not, for example, object to the provision of digital research tools in lieu of books, other portions of the standard should be retained, and guarantees of minimum access to kiosks or tablets or to trained law library staff need to be clearly spelled out. The board should deny the correspondence request as vague, unnecessary, and premature. It seeks a variance from the entire standard based on rules that haven't been announced yet. procedures that will exist for identifying individuals for whom correspondence needs to be restricted. The board should deny the requested variance regarding telephone calls. While we appreciate the technological challenges in installing phone lines, daily access to speak to family and friends is, if anything, more important for young people than for adults, and the same standard should apply in the SSDs. Finally, the board should not give the department permission to abrogate the law. Correction Law Section 611 clearly requires that newborns stay with their incarcerated mother if it is in the child's best interest. Wraparound and supportive services, even if provided, are not a substitute for a child being able to live and bond with its mother. The board standard only requires the department to figure out a way to safely and appropriately house mother and child together to comply with the law. This variance should be denied. Thank you.
Thanks very much. The next speaker is Kate Rubin.
Good morning. My name is Kate Rubin. I'm the Director of Policy at Youth Represent. We provide legal representation to court-involved youth 24 and under. At the core of the movement to raise the age is the fundamental truth that youth are different from adults, both developmentally and legally. Not only should they not be incarcerated with adults, they should not be incarcerated in adult prisons or jails. That principle, along with the principle that no young person should endure worse conditions of confinement because of raise the age, guide our positions and comments on each variance below, which we detail in our written comments. On 104B2, the wet cells, we support the amendment with strong, we support the proposal with a strong amendment echoing our colleagues. We do agree that adding toilets and sinks to sleeping rooms at Horizon is antithetical to the goal of creating a home-like environment that doesn't resemble a prison or jail. However, we are deeply concerned about the possibilities for abuse when access to toilets is solely at the discretion of staff. So we strongly support the amendment for the 5-minute, absolute 5-minute maximum with immediate access to toilet as the standard and a strong reporting and oversight mechanism for that, for that variance if it's approved. For 108F, the law library, we don't support or oppose the idea of replacing books with technology. We think there's a lot of opportunity for high quality, up-to-date, accurate know your rights information, which should be available to youth, as well as Lexis access, and that the proposed on-call legal coordinator should respond to all requests within a maximum of 24 hours, and to ensure that the legal coordinator is sufficiently objective to effectively assist youth with grievances, the legal coordinator should be employed by an outside agency. 111 correspondence should be rejected, as my colleague from Legal Aid said, because it is vague and has no procedures actually outlined for identifying individuals whose mail correspondence is prohibited. 306E5, the nursery program and necessary child care should be rejected. We understand that the physical plant of Horizon can't accommodate a nursery, but given the tremendous benefits to parents and children of keeping them together, keeping newborns together with their mothers, and the extremely rare circumstances where this is necessary, if it even ever happens, we think that if a young woman gives birth in SSD or SJD custody, the city can and must make arrangements to keep the parent with the child in those rare exceptional cases. Telephone calls, we don't oppose or support this variance generally, the variance request generally, but we do oppose the specific provision that additional discretionary phone calls would be directly tied to a positive behavior management system. We think that family connection and support when available is crucial for teenagers, and that phone calls can be rewards for positive behavior, but may be equally appropriate or necessary to provide additional phone calls to a child who's struggling with behavior or emotional problems. Thank you.
Thank you very much. The next speaker is Kelsey Da Beulah.
Good morning. My name is Kelsey Da Beulah. I'm the Jail Services Social Worker for Brooklyn Defender Services. And just due to time, I'm going to try to be brief and not repeat what's being said. But our office does echo the comments from our colleagues from Legal Aid and Children's Defense Fund. I do want to point out, one thing I want to discuss is the telephone calls. The department is proposing to limit a young person's access to communication. It's a crucial tool in any person's ability to stay connected to their family and loved ones, especially a young person. We have grave concerns, and as we've seen just in the years past, families, directly impacted folks, advocates have come up here to tell you how important communication and connection with their community and their family, their loved ones, is to anyone's incarceration. Telephone calls, for example, are a vital link to support systems at home and must not be used as a bargaining chip to incentivize good behavior. According to the variance, young people in the new facility will start with 3 7-minute calls a week. This is almost identical to the limitations that are placed on adults in 23-hour solitary confinement. Then in a different variance request, the commissioner mentions, and I quote, under existing ACS juvenile detention model, law libraries are not provided in juvenile detention facilities because there is concern that youth may engage in legal research that may lead to them to file papers that incriminate them. They are encouraged to consult with their attorneys. But under this telephone call variance, if passed, phone calls will be limited to 3 a week. The department is seeking to undermine the fundamental right to counsel communication that a person relies on to discuss matters that will ultimately affect every component of their life. Young people will be forced to choose between calling their loved ones who provide life-saving support or their legal representative who is crucial in fighting their case. I say all this really to point out that there are so many unanswered questions, and there's a lot of vagueness in these variance requests. Advocates coordinate their schedules to attend and be a resource at these now monthly adolescent young adult advisory board meetings that we only learn they're canceled the day before or sometimes the night before. The public and the advocates have a right and a need to know how the department plans on implementing these proposed changes, especially when it involves young people, who are some of the most vulnerable in our system. The board also has a responsibility to pressure the department for clarity and request for corrective action steps that will be taken to ensure the rights of young people are not violated. Thank you.
Thank you. The next speaker is Nancy Ginsburg.
Good morning. My name is Nancy Ginsburg. I oversee the adolescent practice for the criminal trial practice of Legal Aid. Legal Aid Society opposes the variance request concerning commingling. This variance has been in effect for almost 3 years at this point, despite requests by the BOC for monthly progress reports on the implementation of the young adult plan. The data provided is both insufficient and concerning. As part of winding down the GMDC facility, young adults have been moved elsewhere, and now 60.9% of young adult men were outside of GMDC by April, the last available report. However, information detailing which facilities in which these young men are placed is not available. The reports also lack information about how these commingled units are composed, how decisions are made to remove young adults from dedicated housing, whether these decisions are reviewed or altered, and how often young adults are given the opportunity to change their original responses, indicating interest in school or programs. The discrepancy of young adults participating in programming is stark and concerning. In May 2018, 75% of young adults were involved in programming in GMDC. In contrast, the participation rate of young adults in commingled units was 12% for external programming and 13% for internal programming. While the types of programming offered in GMDC are detailed in these reports, there is no information about what programming is offered in other facilities and whether it is appropriate for this age group. Staff training also appears to be quite different for officers dedicated to young adults and those in commingled housing. While 96.8% of uniformed staff in GMDC have received safe crisis management training, only 53.6% of uniformed staff department-wide have received such training. We have received reports from clients that when they are held in buildings where programs are not a priority, uniformed staff are less inclined to facilitate movement to and from program areas. Young adults who are housed with officers who are not specifically trained to work with young people are less likely to respond appropriately to this age group. The board should insist on more transparency in the process of housing young adults, including protocols for decision-making on what type of review takes place, what programming is available for young adults and in which locations, descriptions of educational and vocational programming and availability. Given that the majority of young adults are not in young adult housing with dedicated programming, it appears that the department lacks the will to provide age-appropriate programming opportunities to young adults, and the board should enforce the standard in 1-02. Thank you.
Thank you. The next speaker is Jennifer Parrish.
Good morning. My name is Jennifer Parrish. I'm the Director of Criminal Justice Advocacy at the Urban Justice Center Mental Health Project. We continue to oppose the variance to minimum standard 1-17, which permits DOC to keep people in solitary confinement beyond 30 days. The United Nations standard on the treatment of imprisoned people, known as the Mandela Rules, prohibits confinement more than 15 days as it constitutes torture. We should have such a limit on isolation in the New York City jails, and this waiver moves us in the opposite direction. While we're pleased that DOC has not used the waiver in the last 6 months, I think that is largely due to the board's conditions that were placed on it and also the reporting requirements. So I support the comments that were made by my colleagues regarding the changes in standards that would apply in the juvenile detention facilities, and I think it's critical that any of the variances that you address have conditions that require that the protections that underlie the standards, even if they're carried out in a different way in these facilities, are still there. So for example, with law libraries, if that's provided in a different way, that's one thing, but there must be rules regarding the amount of access that adolescents have to tablets and to a legal coordinator. It can't simply be left at an assurance that DOC gives that there will be adequate access. The board should define that, as well as the number of hours that the legal coordinator is available. Similarly, if there aren't toilets and sinks in their cells, then there must be a requirement that staff respond to their request to use the bathroom within 5 minutes, as is the best practice in juvenile detention facilities. If there's not a nursery in these facilities, then there have to be provisions that would allow a girl who is pregnant to have her child with her, just as she would in a adult jail. The bottom line is that youth must be protected. Raise the age should not result in people having fewer rights in detention facilities. These conditions should not be more oppressive than the city jails. And I urge the board to place staff in this facility so that you can monitor not only whatever variances you permit, but also the rest of the minimum standards. Finally, we continue to oppose the variance that permits young adults to be commingled with adults. It's very concerning to me that the young adult plan seems to have been dismantled. While DOC expressed support for or a continued commitment to it, it seems like that is not what's happened, as some of the previous speakers have described. If you look at their reports for June 1st, there are actually only 7 housing areas that have 10 or more young adults in them. So I urge the board to support the young adult plan as it was originally conceived. The whole purpose was to make sure that young adults have age-appropriate programming and access to education, and I hope you will continue to require that by rejecting this variance. Thank you.
Thank you. The next speaker is Jane, and I can't read the last name, from Our Children. I'm sorry.
I'll submit written comments. Our Children supports the denial of the variance regarding the 16 and 17-year-olds, with particular reference to the inadequacy of a description of how child care would be conducted. A year ago, it took, over a year ago, it took almost that long for ACS and DOC to arrive at a simple memorandum of understanding that would control admission to the Rikers nursery. It's very hard to believe that this simple statement that DOC and ACS will, quote, provide for child care is adequate. That's really very, very inadequate. We know from the Rikers nursery that the first year and the critical element of bonding occurs between mother and child. If that's true for adult women, how true must it be for 17-year-olds who maybe are in a first pregnancy? Please deny that variance. Thank you.
Thank you. The next speaker is Rosa Jaffe.
Good morning. I want to thank the board for their time and consideration today, as always, their commitment to thoroughly assessing each and every issue brought to their attention. My name is Rosa Jaffe, and I come to you today in my role as a licensed social worker. I would like to use my previous experience working in family court as a licensed social worker with the Legal Aid Society's juvenile rights practice for 5.5 years to speak against the variance allowing for a nursery to not have to be built at Horizons. During that period of time, I worked as part of the representation for the child on delinquency cases, child abuse and neglect cases, as well as crossover cases where children are involved in both juvenile justice and child welfare at the same time. In my experience in child welfare, I gained a lot of firsthand understanding of the importance of developing a secure attachment bond between infant and biological parent, as well as the detrimental impact and long-term consequences for child and parent when the bond is not created. In my experience in juvenile justice, I experienced firsthand why youth are placed in a secure detention such as Horizons, which has much less to do with behavior that falls into the category of imminent risk, which is the standard for a removal of a child on a child welfare case, and much more to do with AWOLing from their parole placement or not complying with an alternative to detention program. Although I will say with AWOLing, we often did know where they were. But most of all, I learned about trauma. To not provide a nursery in Horizons is to open the door to adding more trauma to the lives of youth who oftentimes, when you read their INR, you also see that they have so much trauma in their histories already. I ask that you consider to have Horizons build this nursery to possibly open the door for opportunities for youth to become better parents, to gain parenting skills, to bond with their children. I also want to mention, while we are focusing on parenting mothers, the nursery could be an opportunity for teenage fathers, who I also came in contact with quite frequently throughout the juvenile justice system, to bond with their children as well in a more appropriate setting. Thank you.
Thank you. The next speaker is Sanjita Chowdhury.
Good morning. My name is Sanjita Chowdhury, and I'll be speaking on behalf of New York City Council member and Chair of Committee on Finance, Daniel Drum. Unfortunately, Chair Drum could not be here today, but he feels very passionately about these issues. While the plan to move detainees off of Rikers Island moves forward, the Department of Correction requests variances that evince a lack of preparation for this impending closure. Instead of channeling its efforts to de-escalating violence in our jails, the DOC is requesting variances that would not only subvert the board's efforts around punitive segregation, but also allow for age-inappropriate housing of younger offenders. I reiterate my past concerns around the use of punitive segregation and renew my call for the board to deny this variance request. I also encourage the board to deny the DOC's request to commingle young adults with adults 22 years of age and older, unless the DOC can show how this furthers rehabilitative and reintegrative goals. My own knowledge about the psychology of young people people is that while their brains are still developing, it is important to have them in age-appropriate settings. The commingling of 19 to 20-year-olds with those 22 and older seems antithetical to that approach. I ask that the board defer to the experts on this issue and deny the request if the DOC cannot provide adequate evidence. Lastly, I have serious concerns about the rollout of Raise the Age and DOC's involvement with any facility that holds individuals under 18, and I ask that the board proceed very cautiously. I will continue to gather information to ascertain the situation and encourage the board to do the same. If the board does not have adequate information at this time, the relevant variance request should be denied. 4 years ago, the DOC made a commitment to reform, but has sadly backtracked on many of its promises. While the City Council, the board, and advocates work very hard toward implementing the changes so desperately needed in our jails, the same cannot be said about the DOC. Thank you.
Thanks very much. That concludes this portion of our public comment period. Now we will begin the process with the variances. So the next items on the agenda are CHS variance requests. All three are variances that the board has renewed every 6 months for some years. In 2017, the board voted unanimously to integrate these variances into the minimum standards. The first variance is to allow psychiatrists to see and evaluate stable adult patients on psychotropic medication in general population at least every 28 days rather than every 14 days. This variance was first granted by the board in 2005 and has been repeatedly renewed. CHS requests 6 additional months. CHS reports that there are approximately 2,470 patients in New York City jails, or about 30% of the current population, with psychotropic medication orders. Of these, around 1,300, or 54%, are on a 28-day prescription schedule. Of the rest of the patients with psychotropic medication orders, 21% are in mental observation housing units, and by policy are on prescription schedules of 14 days or less, and 28% are in general population and are on a 14-day prescription schedule. Unless the board has questions for CHS regarding this particular variance, then we'll proceed directly to a vote. Are there any questions on this variance before we? No? Okay, is there anyone want to make a motion to, yep, is there a second? Second. Are there any questions, comments? Okay, thank you. No, anybody want to propose a condition? I see not. So, let me just find my place here. Is there a, so we're ready for a vote on this one, right? Okay, so we'll take a vote on this variance. Mr. Reagan? Aye. Mr. Sherman? Aye. Dr. Sapir? Reno? Mr. Richards? Aye. Hamill? Aye. Dr. Cohen? Aye. Jones Austin? Thank you. Variance carries. Next, we have the second variance is to allow CHS to either use interferon gamma release assays or tuberculin skin tests for tuberculosis screening, and to exempt from repeat screening those prisoners who have had a documented negative test in 6 months prior to their admission. CHS reports that they now have had many years of experience with IGRA and is a valuable and effective tool in controlling tuberculosis in the jails. This variance was first granted by the board in 2013 and has been repeatedly renewed. CHS requests an additional 6 months. Again, unless the board has questions for CHS regarding this variance, we'll proceed directly to a vote. Is there a motion? Is there a second? Okay. We'll take a vote. Any conditions? We'll take a vote on this. Mr. Reagan? Aye. Sherman? Aye. Sapir? Reno? Aye. Stanley? Aye. Yeah. Aye. Yeah, I vote in favor. Thank you very much. The variance. It's passed. And so now Martha will talk about the third variance.
The third variance is to allow healthcare staff to provide the Department of Correction with specific diagnoses related only to injuries sustained by prisoners while in correctional custody. The reporting of diagnoses unrelated to an injury remains prohibited. CHS reports that sharing the injury information has since served as an essential component of DOC investigations into violent incidents. This variance has been granted by the board since 2013, and CHS requests an additional 6 months. I just want to note that in an attempt for the board to better understand how DOC and CHS respond to, track, and report the injuries of people in custody in DOC facilities, and also to understand the rates and types of serious injuries occurring in the jails, we are currently engaged in fact-finding and data review on the policies and procedures relating to the tracking and reporting of specifically serious injuries. We've been pursuing this work since March, and we expect to provide a full report to the board on the issue in advance of the expected future variance renewal in 6 months. I just wanted to make that note, and now you can proceed with.
Could I get a motion to vote on the requested 6-month variance to allow the healthcare staff to provide the DOC with specific Thank you. Is there a second? Second. Okay. Anybody have a question or comment they want to make? Anybody want to propose?
I just want to second Martha's process of. This is very important that the board and the department know as much as they can about serious injuries, and this is an important variance.
Thank you. Any other comments? So now we'll have a roll call vote. Mr. Reagan? Aye. Sherman? Yes. Dr. Sapir? Aye. Perino? Support. Aye. Judge Hamill? Aye. Dr. Cohen? Aye. Yep. Ms. Jones-Austin? Aye. Thank you very much. The motion carries.
So now we're going to move into the 2 DOC variances. I just want to make one statement about the first variance. So as we know, in September 2015, the board first granted a variance for minimum standard 1-17D2 to allow the department in highly exceptional circumstances presenting safety concerns to waive the requirement that people in custody be immediately released from punitive segregation for 7 days after they have been held in segregation for 30 consecutive days. The board has renewed this variance multiple times, each time on the condition that the chief of department must approve each request, and statewide placement in a less restrictive setting is not a safe option. The board last renewed the variance in January 2018 and has asked the board to consider a 6-month renewal. I just want to state that, as in the past, the board staff have published a report on the department's use of the variance, and since the board first granted the variance in September 2015, the department has granted 27 waivers and denied 10. In the last 6 months, the chief of department has denied 1 and approved 0 in the past 6 months. I just wanted to make that statement about the report that's on our website, and now we're going to turn it over to, I see 2 people, to the commissioner. So I think first. Thank you.
Good morning. I just wanted to address the event that happened in the jail yesterday. At approximately 2:30 p.m. yesterday afternoon, a detainee in custody at the Anna M. Cross Center on Rikers Island was fatally injured after being attacked without warning by another inmate. Corrections officers reacted quickly in separating the individuals, rendering aid to the victim, and calling for medical assistance. But despite everyone's best efforts to revive him, he was not able to be saved. We take what happened very seriously. It's troubling to everyone. The safety and well-being of people in our custody is our core mission. And so it's devastating to all of us when something tragic like this happens. The suspect has been identified, and we are collaborating with the NYPD and the Bronx DA's office on this active investigation, and we will keep you updated as things move along. Thank you.
So good morning. Currently we are asking for an extension on this variance for the 7-day PSEG waiver. Can you hear me better? Okay. So to date, we have approved 27 and we have denied 10. And as of recent, we are now putting explanations on as to why we feel that for safety and security concerns, that a person should not remain in a less restrictive housing.
Chief, why not use NYC for this period? Because it seems, I mean, isn't it safe enough in terms of protecting other people?
So what I say is it depends on the egregiousness of the act in which the inmate commits, because there's a lot of things that's looked at. His history, as well as the time spent, as well as we have the counselors actually speak to each inmate to determine if we think that it's best or safe for everyone to go in, as well as video evidence, reports, and everything else before I make that decision.
I just want to acknowledge you made a commitment to really take a hard look at how the waivers are happening, and you have done that over the last 6 months, 0. So I just want to acknowledge that, because I think that is progress. That's about you saying what you're going to do and you follow through. So I just want to acknowledge.
Thank you.
That work.
I support that also. Thank you for that.
I just want to correct the math. You turned one down and you didn't do anything.
Yeah.
I think you've been judicious and thoughtful and
So there's a lot of thought that's being put into and a lot of work that's happening behind the scenes so that we can correct the behavior.
Thank you.
Thank you.
Okay.
Any other comments or
any other questions?
Questions from?
Yeah, I'd just like to say, I mean, that's a really long decision that you do make, and to have it 0, there's so many things happening. I think you do an amazing job, and you know, just to your credit, great job.
Thank you.
Is there a motion?
What's the item?
Is there a second?
Second.
Any other questions or comment? Any conditions to be proposed?
We have one existing condition on the variance, which I'll read. During the pendency of this variance, the Chief of Department shall approve all waivers in writing. Her approval must specify her reason for granting or denying the request, what other housing options were considered, and why each was not a safe option. Immediately after the Chief's decision is made on a request, the Department shall send to the Board the request and the Chief's decision.
Now, do we need to approve that condition separately? Or?
We should, yes.
Yeah. Okay, so we're going to vote first on the condition that Martha just read. Mr. Reagan?
Yes.
Ms. Sherman? Yes. Dr. Sepier? Carino?
Support.
Richards? Support. Yep.
Yes.
Dr. Hammond?
Support.
Yes. Thank you. That carries. Now, the variance itself. We've had a motion and we've had a second. If there are no other comments or questions, we can take a vote on that. Mr. Reagan?
Yes.
Sherman? Yes. Safier? Carino? Richard? Judge Hamel?
Yes.
Dr. Cohen?
No.
Yep, I vote in favor of it. Okay. So that variance is now approved. We go to the next variance, which is a young adult commingling variance request. In 2015, the board created a unique category of incarcerated people, young adults ages 18 through 21, who are to be housed separately and apart from the specially trained staff and resource-rich, age-appropriate programming. These reforms were intended to allow for a comprehensive youth plan that would mitigate trauma and disproportionate impact on young people of color and thereby reduce violence. Since July 2016, 18-year-olds must only be housed with 18 to 21-year-olds. However, the rule has never been in effect for 19 to 21-year-olds. Since 2015, the board has continually passed variances allowing the department to house 19 to 21-year-olds with adults. The board last renewed this variance in January 2018, which is set to expire on July 14th, 2018. The department has asked the board to consider a 6-month renewal of the variance, allowing for the housing of 19 to 21-year-olds with adults. They have additionally requested the board to consider amending the minimum standards to incorporate this variance permanently. As some additional context, in the fall of 2015, the department announced it would house all young adults at one facility, GMDC, provide age-appropriate programming, and train staff to work with this population. By June 2016, the department housed about 75% of young adults in GMDC. Violence at GMDC spiked over a 2-week period around this time, and the department decided immediately to move some young adults and ultimately to keep only 50% of the young adults in GMDC. The department closed GMDC on June 27, 2018. The department is currently housing all general population detainee 18-year-olds and young adult only housing at RNDC. The department reports they will add more young adult units at RNDC once the Raise the Age initiative is implemented in October 2018 and the 16 and 17-year-olds are all relocated. Ultimately, the department told the board last month that a majority of young adults will be housed at RNDC. As of July 2nd of this year, 34% of young adults were in the young adult housing. This includes 96% of 18-year-olds, 132 people out of 137, and 19% of 19 to 21-year-olds, 111 out of 582. The board applauds the closing of this jail and the important steps toward reform that this represents. But the board is concerned about what this will mean for the young adults in custody and the department's young adult plan. Specifically, the board seeks to ensure that education and programming access is improved and that appropriate training staff are working with young adults. Will the department please present its variance request and update the board on its current plan with respect to young adults?
Good morning. My name is Timothy Farrell, Deputy Commissioner, Department of Correction. I'm here to give an update on where we are with the young adult housing plan, where we're going, how we're going to improve that, how we're going to increase the young adult housing units. I will speak on that plan. I will defer to my colleagues, Deputy Commissioner Saunders and Deputy Commissioner Tauzik, for any program-related questions as they oversee the programming units, both in young adult and adult programs. As of yesterday, our latest data is we had 684 young adults in our custody. Those are 18 to 21-year-olds. 84 of those are city sentenced. 600 were detainees. We have 163 that are identified in some form of special population status. That could be MO units, new admission processing units, PC, infirmary, or some of our specialized units for problematic behaviors. There are 211 young adults housed in pure young adult units between the facilities of AMKC, RNDC, GRVC, and EMTC. And we have 300 young adults that are commingled in other units throughout the agency. That works out, of the 521 non-specialized or non-special population young adult inmates, that 221 represents 43% of our young adult population as being housed in pure young adult housing units. The 300 remaining equal 57%. We have EMTC identified to deal with our city sentence population. We have 2 housing units at EMTC dedicated for young adult housing. Those would be 4 main and 10 main. We have GRVC identified with 3 pure young adult housing units, 4A, 4B, and of course the secure unit. AMKC, we use quad upper 5 and quad upper 7 as pure young adult MO units. And RNDC, we have identified 16 units within RNDC that are currently housing young adults. So as an agency, we have a total of 17. What we plan on doing with the consolidation of GMDC, a lot of work went into that consolidation, and we knew we had a lot of work to do to replicate what we had at GMDC into RNDC. And working collaboratively with the SCOC, we aggressively put forward design plans to remodel certain areas of RNDC so we can replicate the YES and the Peace Centers and continue that programming and expand the programming necessary for this population. We have received the approvals necessary to begin, and we have a preliminary timeline of about 24 weeks to have those programming centers up and running at RNDC. As we move forward, we will continue to move young adults into RNDC and increase the young adult populations within those 17 housing units. And as the adolescents transition into the Horizon Center in October, we will gain approximately 15 to 20 additional housing units at RNDC that will be left vacant with that transition to further increase the young adult housing at RNDC. Within the next 3 to 4 weeks, we anticipate having a young adult pure housing area for the GP inmates at somewhere between 60 to 65% of our agency population.
Your questions. I know we spoke about this a little bit last month, and now that this variance is before us. What percentage of the 18-year-olds are in housing units, young adult, with just other 18-year-olds?
Pure 18-year-olds?
Yes.
I don't have that specific data, but they are all with either 18-year-olds themselves or 18 to 21-year-olds. As we've increased our young adult population at RNDC, we have begun to commingle some 18-year-olds with those 19 to 21-year-olds in order as space became available.
Okay, and as our chair and our executive directors recounted, there was an awful lot of work done by many, many people who were present in this room, including Deputy Commissioner Saunders, myself, all of the advocates who spoke here today in opposition to the variance because of all the work that was accomplished and what appeared to be a fair amount of success at GMDC, enormous amounts of renovation that were done. So my question is, back before this anticipated closure of GMDC, originally the goal had been to try to keep 18 to 21-year-olds together about 75 to 80%, knowing that there was going to be a certain percentage that might be in specialized housing or would need some sort of disciplinary housing and wouldn't be able to be there. The whole idea is to try to make a really safe place where they could have enhanced programming, enhanced recreation, access to school, all those different things. Now, I believe it was just stated that you'll be asking us in rulemaking to essentially undo the young adult plan that was agreed to in our rulemaking back in 2015. So my question is, what is the percentage of young adults do you right now intend to house in a young adult housing so that they can get the full benefit of specially trained staff, age-appropriate housing, age-appropriate programming, enhanced recreation, and the like? Because the whole idea is to give these young people the best chance that we can at success when they're ultimately released from Rikers.
Sure. I believe I mentioned that until Raise the Age is fully implemented and those housing units become available to use, we are looking to get anywhere between about 60% of our young adults into RNDC and GRVC pure young adult housing units.
I'm sorry, did you say before or after Raise the Age?
Prior to.
Okay, what about after Raise the Age? We now have all the 16 and 17-year-olds out.
We would increase. We would look towards increasing that number as high as we can in order to ensure safe and secure housing. This is a population that is challenging based on separations and other issues. There will probably always be some element within that population that we will not be able to manage in a pure young adult setting. But that doesn't mean we're not going to continue to work towards maximizing those housing units, maximizing the availability of that programming, can't stand before you right now and give you a definitive number of what we're looking at. It's done on a case-by-case basis, similar to what happened in July of 2018. We were at a level. Issues began to develop. We had to back away from that number. So I can't say that that won't happen again, but I can say that we are working towards ensuring the safest housing plan and the most robust programming for this population. And RNDC is giving us that option, and the team is working towards accomplishing those goals.
Well, what would you say were the categories of young adults that you could not accommodate in young adult housing? How would you describe that population, or what factors go into that?
Well, until the new admission processing right now, only 18-year-olds are processed into RNDC who are newly admitted. The 19 to 21-year-olds are currently being processed in all of our intake facilities. As RNDC, as we lose the 16 and 17-year-olds, we will begin to process all new 19 to 21-year-olds entering the system in new admission units at RNDC. So that special population would be eliminated from that category and move into pure young adult housing units. There are certain protective custody issues currently in place based on separation issues that we need to manage in commingled protective custody housing units. There is certain mental health assignments where the young adult population is managed under the care of H&H and their determination for the housing. Our PACE and CAPS units are not available at RNDC. The infirmary issues, ESH, so those are our primary areas where we may have to separate the population and move them into commingled environments.
So, I'm concerned that if we move to get rid of the, what assurances do we have that you will continue to work in a manner to house those that can be housed separately accordingly? I'm asking that if this, they're asking that this rule be changed. What assurance does the board have? What assurance do we have as a city that you will continue to work to ensure that those that can be housed separately will be housed?
Our commitment to this, I understand your concern.
I'm not intending to be disrespectful in the least. I appreciate the effort, but sometimes rules are in place to help drive activity in a certain manner, and when things become difficult to manage without rules, then commitment is one thing, but action is another.
Well, we have demonstrated that even with GMDC closed and RNDC still occupied by the 16 and 17-year-olds, we have worked pretty aggressively to increase. I heard some percentages that were cited earlier. We're already at the 43% threshold. Matter of fact, if I ran the data now, we have transferred additional young adults into RNDC, so that number is probably higher today if I go back to the office and run it. So we have continued that process. We haven't stopped our mission at doing it, aside from me giving you the assurances that as the agency and in my position, we are going to continue this. We have a team, we've invested a lot of resources, and we understand what the goal is and what your goal is to provide a certain level of care, custody, and programming for this population. And I can only assure you that we are going to continue that process because we have a lot of dedicated people who have invested a lot of time. And besides, we're investing, again, a lot of resources into replicating the programming areas at RNDC, similar to what we had at GMDC. So as a city resident, we'd like to maximize those areas as best as possible.
Dr. Cohen.
The way it looks, obviously, to the people who spoke before, and the way it looks to many of us on the board right now, there's there's some disconnect between what you're saying and what's happened in the past. I can see a change perhaps in your presentation today, and bringing the things that you're proposing to do, some of which you couldn't have done before, such as the intake. I don't know why MOs couldn't be, available to young adults. If there's a clinical need for CAPS units for young adults, that could be arranged also. I think it's very important to note that the department has actually created, at this point, there are 4 separate housing cohorts. There's a 16 and 17-year-old, there's an 18-year-old, there's a 19 to 21-year-old, and there's an over 20, and then there's a 22-year-old and up cohort. And that is not what the board intended with the young adult program. You decided, for reasons that have to do only with Nunez, I would suggest, create a separate 18-year-old cohort, which you are staffing as the young adult program was supposed to be staffed, with lots of programs, which you are supporting in terms of security staff with additional staff in every housing area, which you should do. And we talked about when the young adult plan first happened, providing additional security staff for that population as well. And I think the board wants you to, and the city and the country thinks that there's a reason for the young adult program, even beyond 2022, because of the condition of these young people's brain, to enhance programs for this population and cohort them together. And I think we're going to be urging you to do that. I don't think the board may go into rulemaking to be more aggressive in terms of, so that what happened over the past 3 years doesn't happen again, where the number of people in young adult housing non-commingled goes up and up. But I do appreciate what you're doing right now in terms of reversing that thing. But I think we need to see a lot more progress, and particularly in programs, extra security staffing to deal with the violence issue. It's important. The board's staff has reported to us that your argument in multiple requests for increase for this variance for commingling is that it is a safer thing to do. And our research staff review of the data does not suggest that commingling is a safer way to run the jails. It suggests that young adults, have an increased, tendency towards violence, but that commingling does not decrease the amount of violence being performed. I think the amount of violence that's going to be happening in this population will be decreased if you have more security staff in young adult units. Thank you. Good job.
Initially when I saw the variance, I saw 86% commingled, 14% not. And I was concerned about that because I felt that variance might be a custody management tool for the department, to house our young adults. But I've seen, since you've been talking, that your goal really is to get it back to where it was in GMDC. And I got to applaud you. I've never seen SCLC ever approve variances the way, not variances, but approve structural change the way you got it done. Years and years go by and they usually don't get it. So I'm being told that a lot of your requests for change in RNDC has been approved. Is that correct?
That is correct.
That's amazing.
In addition to the piece in yes Senate, we've also put in requests, and I believe they've been received and will soon be acted on, is to increase the outdoor recreation yards, what we refer to as the Chevron yards. So each building will have its own outdoor recreation yards, which will permit more outdoor recreation specific to the housing units that the young adults are assigned to. So we have one, the building 2 yard is about 2 weeks away from being able to be used, and then we have plans to modify a series of other recreation yards, which will add to that both internal programming, interior to the building, and then external, which we all know is important to get these kids outdoors and tired.
And like I said, that's all real great stuff. And to be at 43%, with your limited spacing, that's a real strive. Now, I feel like the variance should be focusing on safety. If a young adult does not want to program and starting havoc in young adult programming, then I think that particular person should be commingling. So I think commingling should focus a lot on security and safety, and the termination of the young adult not wanting to, be in programming staff. But I think 43% is really going in a great direction. You say it's even higher now. So, like I said, initially reading the variance, I was very concerned, but seeing the direction you're going in, that's all good stuff. And when the 16 and 17-year-olds do go to ride, you're going to have a lot more space. And if your commitment's in the right direction, which I see it really is going in the right direction, I applaud your effort, and thank you.
Could you speak about the services, being that you moved young folks into RNDC? What is the suite of services that they are offered? How many of them are engaged? Have you had a chance to sort of look at that?
For that, I'll defer to Deputy Commissioner Summers.
Thank you.
So good morning, everyone.
Good morning.
And I have to just say that I wanted to put this conversation in context, and it's really important and it's really inspiring that the board has been in support of all the work and the commitment we have made to the young adult plan. It was the department's idea to create a young adult plan, and you guys supported us. So I think today it shows that we are really in a place of collaboration and hoping that we move forward in that direction. With that being said, with response to your question, Mr. Richards, the young adult suite of services followed the kids to RNDC. So in general, everything that was offered in GMDC has now followed, with the exception, of course, of the Yes Center. We actually have some of our workforce development courses happening in the trailer in the Sprung because we don't have the Peace Center, but that didn't stop us from providing those integral courses for these young people to successfully reintegrate back into the community.
Any further questions? So the department, I think you were probably in the middle of your presentation. Do you have anything further you want to say?
No, I believe I've explained everything on where we are, where we've come, and where we intend to go.
Okay. I just have one question. Does H+H, are you going to be setting up either MO units in RNDC, CAPS or PACE CAPS units or PACE units in RNDC? I understand mental health staff moved from GMDC to RNDC.
So AMKC upper 5 and 7 is the area we had identified for the young adult MO as part of the GMDC closure for now. I don't have off the top of my head the numbers and the need, but we could get back to you with that information.
Okay. And if you could investigate what the possibilities are of having an MO unit in RNDC. Thank you.
I just want to make one note about the numbers because people are throwing around different numbers. It's a bit confusing. The numbers are not that far apart, but when you reference the 43%, we're not talking about the full young adult population. So that excludes young adults in new admission housing, mental observation units, and other specialized housing. So when you include all young adults, that number is then 34% that are separate and apart. They're not that
large portion of those are the 18s, and that might be changing the numbers. If you separate out, which has been the concern of many of us on the board, is that because our young adult cohort is 18 to 21. When PREA came into effect, and I won't belabor the point that I've been saying for years now, we had to separate out the 18s. So the idea was that 19, 20, 21-year-olds who have very similar brains to the 18-year-olds would get the full benefit. You all have decided to separate out the 18s, but when you separate out the 18s and we look only at the 19 to 21%, what percentage of those young adults are in young adult adult housing?
19%. And 96% of the 18-year-olds are in pure young adult housing.
So the 18s are being given a benefit, the 19 and 21-year-old really backsliding substantially. So I hear what you're saying, and I hope to see those commitments honored, that we do have 60% of the young adults in RNDC by October 1 when the adolescents are moved off.
So procedurally, what we'll do now is we'll have a motion to
3 months.
approve the, is there a motion? There'll be time for further discussion.
Okay.
Move the item, recognizing that Dr. Cohen has a condition.
Yeah, okay, and correct. And then a second?
Second.
Okay, so now if we'll have anyone else who wants to raise an issue with respect to this variance, and also anyone who wants to propose a condition for this variance.
There are three issues. One is to have this a 3-month rather than a 6-month variance. And the other two are conditions. Should I read that?
Yeah.
Okay. During the pendency of this variance, the department shall provide the board with a monthly census showing, and I guess this is a continued, which housing units in jails 18 to 21-year-olds are housed, and the department shall continue to A, provide the board with a monthly progress report on its implementation of the young adult plan and implementation of alternatives to punitive segregation, i.e. second chance, GRU, and secure units, and B, provide its progress reports for each month on the 10th business day of the following month. And the second condition is by...
You have to vote on them individually.
Yeah, but I don't know if I'm just going to put them all out, and then, so there'll be 3 separate votes. By October 9th, 2018, the DOC shall submit a young adult housing plan which will result in the department housing all young adults 18 to 21 in young adult housing consistent with minimum standard 102C. The plan shall include goals and timelines for offering and providing school, recreation, and programmatic capacity, appropriate staffing of young adult housing units, young adult specific training for staff working with young adults, including specific training offered and number % of staff working with young adults who have received the training, evaluating young adults housing impact on system-wide violence, young adult education engagement, and young adult program engagement, and monitoring plan progress. The plan shall additionally include the department's plan for identifying, monitoring, and reporting to the board the rare exceptions in which the department needs to house a young adult in adult housing, e.g. the board's variance allowing the department to house young adults with adults in specialized mental health units, NIC infirmary, and West Facility communicable disease unit.
Doctor, can you state your previous condition again? Just
The
previous one, not that one.
During the pendency of this variance, the department shall provide the board with a monthly census showing in which housing units and jails 18 to 21-year-olds are housed, and the department shall continue to provide the board with a monthly progress report on its implementation of the young adult plan and implementation of alternatives to punitive segregation, i.e. second chance, GRU, and secure, and provide its progress reports for each month on the 10th business day of the following. You're concerned that that's duplicative in the...
No.
That's an existing condition.
Yes.
Yeah. And then the second one is new.
Yes.
And then the third point you made was to
have it a 3-month.
3-month rather than a 6-month variance. Any response to this from the department?
I think I don't have all that language necessarily right in front of me. I think a couple of things that are concerning to us particularly. Certainly on the length of the variance, one of the issues with requesting the 6-month variance is essentially to bridge through the raise the age transition. I think as Senior Deputy Commissioner Farrell stated, we do have specific plans that have to move forward, but obviously a lot of the push by the city right now, as you'll hear in the later presentations, is focused on the raise the age and the ability to properly move the adolescents out of off of Rikers Island, and part of that is kind of transitioning RNDC. So just looking at the calendar itself, July, August, September, running into October doesn't give a lot of runway after that. So very specifically, we were looking for the 6-month variance in order to make sure, one, we can show you our level of commitment to that transition of reestablishing a higher percentage of young adult only housing within RNDC with the proper programming and the space, certainly built with SEOC as the 24 weeks asserted, but 2, also to give us the flexibility then to also ensure that any issues that do arise as we do transition staff and adolescents off the island can be taken care of during that time. So I want to speak specifically to that. I think in terms of the reporting, I don't think we have too much of a concern. I was talking through it, particularly in terms of the numbers, just to make sure that everyone is aware of exactly where the movements are happening. I think that's a concern. Ultimately, on the overall goal, I think, as Judge Hamill kind of suggested, we went into this not having done it before. We committed to moving towards a young adult-only facility. We ran into issues. We talked extensively with the board at that time about what was going on. We had expressed our interest in asserting kind of a 60-65% kind of goal because we knew there was a population for which young adult-only services were not going to be something that we could provide, particularly as it related to either security concerns, mental health concerns, and other kind of those who were disruptive and did not want to actively participate in programming. So I think we remain committed to that, and I think that one of the problems with the condition of kind of asserting that we have to stay within all this is something we wanted to deal with in rulemaking, because I think it's a healthy conversation we have to have on whether or not the full commitment is something that the department should go with, or whether or not it should stand by kind of its overarching kind of percentage of young adults to kind of be housed together, but having the exception for those for some set of circumstances, we can move out and commingle.
Yeah, I'm just trying to understand your position. So is the department okay with the 2 variances, and your opposition is to the 6 months rather than the 3 months?
I believe the opposition is on 2, and we are okay with 1. I think we are in opposition to the time length of the variance, and I think that we are in opposition to the one condition that kind of pins towards an entirety, basically 100% of young adult housing. And then we are okay with at least the reporting. And again, I apologize for not having the exact details in front of me to speak to it, and we are okay with the reporting.
Judge Howard.
Yeah, I just wanted to speak to the issue of 3 months. You all chose to close GMDC and start moving young adults into blended units or all over the jails. So the young adults have already lost the benefit, to a great extent, of the young adult plan. We understand we have raised the age and you're planning, you have to by law move the young people off, the adolescents off by October 1. We know from our years of working together, and we all just know in general, people get much more done when they work on deadlines. And so since you're saying you intend to have 60% of the young adults in RNDC by October 1, I recommend the variance only be for 3 months, and we'll see whether, in fact, you have moved 60% of the young adults into RNDC by October 1. You also seem to be saying, on one hand, we're really committed to the young adults, but on the other hand, in rulemaking, we've said we don't really want the young adult housing cohort to exist. We need to know which way you are going. A 3-month, my experience is, when these variances come up, we get a lot more really accurate, reliable information upon which to make really sound, well-informed decisions. So 3 months appears to be, and you know the reality is you just come back in October with another variance and we'll see where you are. But I don't see a reason to extend it for 6 months and essentially deny a lot of the young people the benefit of what had always been the young adult plan.
Can I just make a further point? This goes to the point you made, Jeff. With regard to the second variance request, which has to do with submitting a report, I'm trying to understand why you would oppose that. Your report, I mean, your plan can have in it whatever you want to have in it. So we would just like to see the plan. So I think it makes sense to...
We're not in opposition to the reporting. No.
Okay, sorry.
No, there's confusion in language. I think he's referring to condition number 2.
Yeah, I'm referring to condition number 2.
Plan in front of Heidi.
Not the reporting.
Plan to come into compliance.
I'm talking about the plan.
I think then simply it's the word all. I don't think we have a problem with the plan for how we are housing the young adults at all. I think that's the issue. The specific language almost commits to that it will be all. And to Judge Hamill's point, I just want to be very clear. The commissioner asserted at the last meeting our commitment to the young adult plan. I am asserting our commitment to the young adult plan just because I have specifically said there is going to be a sub-cohort for which there are exceptions that need to be made does not mean that we are not committed to the young adult plan.
So to address that, your concern on number 2, how about if we change it, which will result in the department housing most young adults? Because I think it was always the plan that it would be a certain percentage.
Or substantially all.
Or substantially all. Whichever you want, right?
Yeah. I mean, I think the important thing is for us to see a plan and all the details of it.
Could I just add to that?
Yeah.
Because I was in the department when we were shooting for all, and when it got around that 70 mark, it was crazy. A lot of people were getting hurt, and I think we did it too quick. So the department shot for the variance because there's nothing more important than safety, and keeping people safe. So that's why the variance worked well then. I mean, with time, we could probably get that number higher when it goes to most, because then we learn where to put people and what works better. But to commit to all, I got to agree with the department that's dangerous, and when people don't feel safe, nothing else matters.
Well, we'll go to substantially all.
Yeah.
I just want to make sure that the board is, we are upfront with the board when we say this. I mean, language sometimes we kind of feel good about what we're saying, but substantially all, I think we have said to this group right now as we go there, before 60 to 65%, we're reading the numbers as we have it. We already have a number of these young adults who are in specialty housing, whatever that breakdown is in terms of the CAPS, PACE, MO, protective custody, ESH. As long as everyone's in agreement that that number may fluctuate everywhere between kind of 60 and whatever percent, we're okay with it.
Well, we'll see what the plan says. We'll see what the plan says. We just like to see the plan.
That's fine. I just want to make sure that everybody.
We're not saying that. You're going to put the new admission housing into RNDC, so that number is going to be taken out of your don't count number and put into the count number. So we'll see where it comes out. You know what we want, and I don't know what you want, and we'll see.
Well, the other issue on number 2 is you've given us an October 9th, 2018 deadline on that, and this is a population that we would have just transitioned the 16, 17-year-olds out of RNDC into Horizons. There is some step-up time that's going to have to be taken to adjust that. Our programming spaces won't be done. We can't rush this population into substantially all of the facilities.
We're just asking for the plan. We're not asking for implementation by October 9th. We're asking for the plan.
Yeah. Okay.
Yeah, we're just worried about the wording because we want to be very upfront with the board on what this means. That's why it's being honest with us.
Yeah, I think
I would just say that if we have to, if we have a variance that uses the term substantially all, I ask myself questions about what does that mean and how does that interpret it.
Yeah.
But substantially, but substantially all suggests that that's 90%, 95%. I don't know what substantially. So that's where I think if we can just take out the word all and then come up with a plan, I think then we can put that plan submit it to the board, and then at that time we can look at what we're working on, and then we can actually have a conversation with concrete details. So to today say substantially all, and then what does that mean what our plan is going to be? There's an expectation that a larger than majority are going to be, or higher than majority, close to 90-95%. So rather than have those questions, it seems like the best approach would be to accept condition number 2, remove the word all, and we can then present that to the board and engage in discussion and dialogue about that. So that's what we would advocate for.
You know what? We're only asking for a plan.
Yeah. Right. So if we have a plan without...
You're starting to write the plan here at the meeting. I mean, let's just leave the language substantially all, and then we'll get the plan and we'll see it, and we'll know what you mean by that. You can tell us what you mean by it.
I just think that I would just ask that if it's all about going for a plan, then why even put the word substantially all in the variance?
Because that indicates where the board would like to see directionally. That indicates what the board would like to see.
Well,
if you can't do that, you can tell us that in the plan.
Well, if we can put that in, add that language that if we're unable to meet that aspirational goal about substantially all, then we have to document and explain that, then that would at least help us. There's some way to lay that out in the report.
Yeah, you can put that in the plan.
Close discussion?
No, I don't want to.
I don't want to stop anybody from the board.
Anybody else has any, or the department?
For the department as well.
Like I said, we're opposing the 3 months. We would like the 6 months to kind of make sure we have the bridge, and then the plan is not a problem.
So, Dr. Cole, I would
on the all for the plan, but otherwise we can certainly provide a plan.
I would just want to ask Dr. Cohen in terms of the length of the variance.
I think the board would do well to know what the status of things are in 3 months, and for the department to begin working right now on its plan, and for us to hear it. And in 3 months we'll talk about it again. But we don't want to wait 6 months to have this discussion.
So perhaps we can get a 6-month variance, but then provide a plan
we want a 3-month
within
variance.
3 months.
I'm sorry, that question was to.
Yeah, I put the question on the floor to get a sense of where people are. It seems that the board is at a 3-month variance.
Yeah.
I mean, just, to be honest, since I was involved with this from the very beginning, we've been waiting for this plan for over 3 years, and it keeps changing. And Vera came in, and they were going to do an assessment of the young adult plan, and they were all ready to do that, and then it started changing and changing and changing. I don't think it's unrealistic, because you all decided to close down GMDC. Right. With all due respect, you made that decision that we should start back at square one. We're moving forward to see what that is.
Yes, and
3 months is reasonable to come back, and if you recall, there were other times where we did variances for a month because we needed to make sure we got the information. I assure you we're going to fully consider this variance, provided that we really are moving forward here.
Judge, I mean, with all due respect as well, I mean, I think that I've been here in the beginning to help develop the young adult plan with many of the people in this room. We have been very open with the board the entire time as we discussed through what the goals have been, what the challenges have been. We've come to you with reports out and variances on the changes that had to be made, why we stopped at 60 and 70% at some point in GMDC within a facility. Some on the board were actually there in the facility helping us out with this. So with all due respect, I think that we are asking for the 6 months because we are, and we have shown that we understand the numbers were low because of initial decision to close GMDC and move people around to other facilities. We have started to move them back into a consolidated facility. Within the facilities that are not RNDC, as Senior Deputy Commissioner Farrell stated, we started to consolidate in young adult specific housing areas. We will move several of those. There are still significant exceptions with the population for which there are commingled housing, whether it's with the security issues or with mental health issues. I think the 6 month is prudent because we are, in fact, right now working through multiple things. And I think that as a board, we ask for that from an operational standpoint. There are a lot of decisions which we'll hear about soon on the Raise the Age efforts as well that require movement from RNDC out and then slowly moving people in. That, I mean, just having the 3 months literally caps you right after the October 1st deadline.
So let me ask the board this. Would you consider a 6-month variance with the October 9th as a deadline for the plan?
No, but I do want to speak to one thing. We have to listen to the department and what they ask, but also all the interested parties. I want to know, we heard from a lot of the advocates. They all opposed us continuing the variance for the reasons that many of us have expressed deep concerns. We have to consider all the interested parties as well as the department, and therefore I think 3 months is fair. I can support it on 3 months. I can't support it longer than that.
So I just have one question. And this is actually a question for my colleagues on the board. We're sitting here talking 6 months, 3 months, and every few months we renew a variance that has been in place, and we have the same conversation where we sit here and we say, well, we want the 3 months, and then 3 months will go by, and then we're going to approve another variance. So I'm just trying to figure out whether or not we're sitting here putting the department through, having them jump through hoops when we're going to be sitting here in another 3 months and then continuing the variance again. And so I am concerned. I appreciate the points that you make, Judge Hamill. I appreciate the points being made by the advocates in the room. But at the same time, I don't want a situation where I'm forcing the department to do something that they really can't do. And I'm actually more concerned about what they consider to be the challenges that would be presented in trying to now push for 3 months, and where they're also trying to abide by the raise the age guidelines. I'd like to understand that a little better, but I don't want to just push for 3 months because we haven't gotten what we want yet, and then we get to 3 months and we issue yet another variance.
Yeah, I think that's a good point. I think to try to reconcile the demands of raise the age with the 3 months variance at the same time may prove problematic. Now, if we can get the report by October 9th, I think that would go a long way to letting us know substantively what the department is trying to accomplish or what they intend to accomplish with young adults. So I do have some sympathy for the push to get the 6-month variance, although I do think we should have the report.
And we're happy to come in and present on it. We're not just provide one of the two presentations and kind of give it up.
Yeah, but we'd like a written report by October 9th. I mean, let's be clear on that. The plan. But, I'd be curious, other board members, please speak up on the question of the length of the variance.
Every time that the Commissioner Farrell comes to see us, he gives us clear vision of what he's up to. He's someone who I have tremendous respect for. I've spent time talking to Dr. Cohen about this. I believe 3 months is enough.
I do too, and I think what Jennifer you raised is a great point in that we're in the 4th or 5th variance, even when we use 6 months, right? We still don't have it. So whether it's 6 months or 3 months, so for me, the 3 months is not about having a plan that's going to be ready, but it is about what you said, Commissioner, about I want to get to 60% before raise the age with, and that's what I'm interested in hearing. That's, for me, that's the 3 months. It's not the plan. We've been through this dance a number of times, and 6 months wasn't enough. 6 months, So for me, it's more about what you've been doing, and that is getting more and more young adult housing. And what you said is that you want to shoot for 60% before raise the age. So this 3 months just allows us to check in on those 3 months, where we at with the 60%.
If that's the consensus of the board, that's fine.
So at this point, it is not the consensus of the board because I don't understand. I haven't yet had the question answered. What are the challenges that are going to be presented in trying to comply with raise the age and push for this 3 month? Or are we going to be back here in 3 months asking for the variance again?
I mean, certainly at the end of 3 months, we will be back here asking for the variance. I think that one of the challenges clearly, as you understand right now, we have moved people out of GMDC and spread them around in order to reconsolidate as many as we can in RMDC. Part of the issue is obviously none of the 16 and 17-year-olds have been moved. There's a lot of effort going on with the city in terms of both physical space for which we would move the adolescents, the training and the selection of staff to make sure that they are ready, and then fully executing kind of a familiarity with kind of the new kind of practices that will come from a joint operation between DOC and ACS. As we move on that, October 1st is the date for which our goal is there. Once that happens, it's not like in one day, all of a sudden, all of the young adults can then move in on October 1st. So from a logistics challenge alone, there is time frame within that that's why I described it kind of as a runway, time for us to kind of increasingly go down that path. October 9th is a perfectly fine time for us to kind of provide a plan and an update on where things stand. But if people on the board, in terms of the expectation for what that 3 month is, will expect a substantially different answer than we are giving you right now, there's not much going to be there. I think that we will be able to kind of say, well, here's our plan, and here's, now that we've had people out, here's where our movements are going to be, but there's no actual physical movement that will be kind of achieved in 3 months, just given the variance is done in October.
Okay, Dr. Cohen, thank you. Jeff?
I think the reason the board needs to have this in 3 months is because the department, based upon its practice, has been going in the opposite direction from the young adult plan, and we want to see in 3 months that it's going in the right direction. This variance has been, for 6 months, has been renewed 4 times already. It's going to be renewed next time, because we're not going to, there's no point in saying that you're out of compliance, but the department's direction has been to spread people to the winds. They decided to close down GMDC, which really makes it very difficult to you know, a 6-month delay in having these critical programs reestablished. I think the board, understandably and appropriately, wants to have the department move in the right direction rather than the wrong direction.
I guess what I would ask you then is, if you just said that in 3 months we're going to be sitting here renewing this again, why would we not just impose certain conditions on the 6-month variance that says in 3 months you have to produce X, Y, and Z, and you have to demonstrate A, B, and C?
I'll answer that. The reason would be that in 3 months we may have different conditions that need to be imposed at that time based upon the progress or lack of progress that the department is making in this. And that's the reason that gives us the opportunity to have this process move forward.
Okay, I think we should just vote on it, unless there's some further illumination, which I can't quite imagine, but we ready to vote on those? Okay, so we have the original variance, which has, I think, 1 condition, right? Yes. And then we need to vote on the second condition, and we need to the original variance has and then with Dr. Cohen's amendment to reduce it to 3 months.
Yeah.
So, I don't know, on the original variance, but which includes the first condition, but with the 3-month extension, is that what we're doing?
Yes.
I think you have to go through the conditions first and then go through the package together. So clarify if we're doing 6 versus 3, and then approve each or don't approve each condition, and then vote as a package.
First condition, do we take the variance as it exists, but reduced by 3 months?
You could decide on time period now, yes.
Yeah.
Sure.
So
let's do time period.
So the first vote is on the variance as it exists, but reducing the time frame to 3 months. And that also includes the first condition, which is already a part of the existing variance, right?
You could do that. Okay.
It's just 3 months, the same thing.
Everybody follow what we're saying?
Yes.
Yeah. Okay. So we've had it. And so is there a motion for that? Is there a second?
Second.
Okay. Mr. Reagan?
Yes.
Sherman?
Yes.
Dr. Stafford?
Yes.
Farina? Yes. Richards?
Yes.
Hamel?
Yes.
Yes.
Strong?
I abstain.
I'm in favor of that. Okay, so, and then the next vote is on the October 9th variance with the October 9th condition, with the change being substantially all rather than all. But other than that, the condition that Dr. Cohen read before. Is there a motion on that?
Of the item.
Is there a second?
Yes.
Okay. Reagan?
Yes.
Sherman?
Yes.
Yes.
Stafford?
Yes. Yes.
Yes.
Yes.
Abstain.
In favor of that. So that carries with the requirement, so the 3-month extension and the
2 conditions.
2 conditions.
Now we...
Don't we have to vote on it now?
Whole
It's
thing.
3 months with those 2 conditions. I think so.
Where's my lawyer?
Yes. Yes.
Is your lawyer.
So now we have a vote on the whole package, as we just discussed. Is there a motion for that?
Of the item.
Is there a second?
Second.
Mr. Reagan?
Yes.
Sherman?
Yes.
Thacker?
Yes.
Reno? Yes. Richards?
Yes.
Yes.
Giordano? Cohen?
Yes.
Jones-Austin?
Yes.
I vote in favor. Okay. That concludes this variance. Thank you very much. Now, Martha will talk to us about raise the age.
So, for the last portion of our meeting, we're focusing on the 5 variances related to raise the age. For the sake of time, I'm going to forego my few remarks and turn it over to Dana Kaplan. We'll start off from the Mayor's Office of Criminal Justice.
Hi, good afternoon. So I think great. Good afternoon, board members, and I'm Dana Kaplan with the Mayor's Office of Criminal Justice. I'm going to start by just framing a little bit where we are in terms of the city's efforts to implement Raise the Age and also what the law itself mandates. So since passage of the Raise the Age law, which the city was very much in support of, we have been focused on an overlying set of goals in our implementation efforts. The goal being to ensure that our criminal justice system is age appropriate and responsive to the needs of youth. Juveniles should be treated as juveniles. That New York City operates a best-in-class juvenile justice system that ensures fair and just outcomes for children 17 years of age or younger without compromising public safety, that the transition to new facilities can occur safely and with an appropriate level of trained staff, and that New York City continues to reduce the detention, jail, and prison populations and does not detain or incarcerate more people after Raise the Age takes effect, and that crime levels remain at historic lows. We've seen some great progress and significant strides in our juvenile justice system, and we believe that Raise the Age can and should build off of those, and that we can see even greater progress. I'm joined here today with agency presenters from the Department of Correction and ACS. Names before you, but Wynette Saunders, Heidi Grossman, Jeff Tam-Kittikassim, Felipe Franco, Tim Roach, and Susan Campos from ACS. So they'll speak more to the content of the variances themselves. In terms of what Raise the Age legislation mandates, the key dates to keep in mind are October 2018, when Raise the Age goes into effect for all 16-year-olds coming into the criminal justice system. There is a specific provision of the legislation that is unique to New York City alone, which is that on October 1st, 2018, all 16 and 17-year-olds must be moved off of Rikers Island. So this is an earlier timeline than the rest of the state has implementation for Raise the Age from a facilities perspective. Between October 1st, 2018 and October 1st, 2019, all 17-year-olds will be detained in the juvenile system, but their cases will move through the adult system. And then on October 1st, 2019 is the final implementation date. Raise the Age will go into effect for all youth arrested under the age of 18. The key components of the law are that the vast majority of cases of 16 and 17-year-olds will be heard in the family court, either originating there or being transferred there from the new youth part of the adult criminal court. Youth whose cases are heard in family court will be processed according to existing juvenile delinquency laws. And starting for 16-year-olds after October 1st, 2018, and 17-year-olds arrested after October 1st, 2019, all felonies will start in a newly created criminal court, youth part staffed by a family court judge. So there's a number of new concepts or components of the law that are new concepts, which might come up over the course of the presentation and discussion, so we wanted to just make sure that they were clear. One, there is a new concept of an adolescent offender, which is a 16 or 17-year-old charged with a felony offense whose case remains in criminal court. Youth parts are where cases for all 13 to 15-year-old juvenile offenders and all 16 or 17-year-old adolescent offenders will start. These judges presiding in the youth part will be specially trained family court judges. There are two types of facilities that the legislation outlines. One is a specialized secure detention facility, or an SSD. That is a detention facility that houses youths who are alleged or convicted adolescent offenders, or AOs. These are subject to regulations from both OCFS and SCOC, and certification by both OCFS and SCOC, operated by ACS in conjunction with DOC. The other facility that is described in the legislation is a specialized juvenile detention facility, or an SJD. This is a detention facility that houses 16 and 17-year-olds that have been removed from Rikers Island. It is subject to those same regulations from both OCFS and SCOC, certification by both OCFS and SCOC, and again, operated by ACS in conjunction with the Department of Correction. So in terms of what the city's plan is as it relates to a facilities perspective, what we contemplate is that juvenile delinquents will be held in an ACS juvenile facility operated only by ACS and with oversight by the Office of Children and Family Services. This facility will be Crossroads, an existing secure juvenile detention facility located in Brownsville, Brooklyn. Juvenile offenders, the ages 13 to 15, will also be housed in the Crossroads facility, subject to oversight of OCFS and operated by ACS. Adolescent offenders, the newly created legal category, who are ages 16 to 17 and must be in an SSD facility. Again, as I mentioned earlier, under the oversight of both OCFS and SCOC, and with agency involvement of both ACS and DOC, will be housed in either Crossroads or Horizon. And then the specific youth who are coming off of Rikers, the 16 and 17-year-olds, that are in an SJD facility, again, subject to the same regulations, and with involvement of ACS and DOC, will be housed at Horizon, as will the gap year youth, or these 1 year of 17-year-olds who are newly admitted into the criminal justice system, are not considered juveniles under purposes of the law in court processes, but are for the purposes of facilities. And I should say that we, well, I'll get more into it. Since we have been focused on Raise the Age legislation and implementation, the Mayor's Office of Criminal Justice has worked in partnership with all of the relevant city agencies, public defenders, nonprofit providers, OCA, and then district attorneys to develop a Raise the Age implementation structure, which is led by a steering committee and has 4 different working groups: the Court Processes Working Group, Programming and Diversion, Data Analytics and Risk Assessment, and then the Facilities Working Group. For purposes of expediency, I won't go into what all of the other working groups are doing, because obviously we're here specifically to talk about the work of the Facilities Working Group, whose goal is to ensure that children in custody in New York City are housed in safe, age-appropriate settings that foster positive development and well-being. As part of our initial facility planning, we reviewed over 70 sites for potential use by October 2018 in order to make sure that we could find an appropriate environment that would be available by the October 1st deadline. For a number of reasons, both having to do with the timeline for any type of land use change for anything that was not an existing detention facility, but also because of our recognition that Raise the Age would mean that a more juvenile-oriented environment was the most appropriate place to house young people, we have focused on renovations to Horizon and Crossroads. And there are tens of millions of dollars of renovations underway right now at Crossroads and Horizon to enhance programmatic, recreational, and educational space, maximize capacity, and make health and safety improvements. These are renovations that ACS believed were necessary either way, but because of the urgency of Raise the Age, we have prioritized them and expedited them significantly. We've been focused on one set of standards and practices for ACS and DOC to ensure that the law and spirit of Raise the Age is implemented, including numerous policies which require submission to and approval of both OCFS and SCOC. And of course, as you know, we've been working with the Board of Correction members in terms of engagement and planning, including presentations on variance working group meetings and facility tours, so that hopefully, as we begin this conversation today, it's not the beginning, I should say, it's kind of a middle point in what's been a productive dialogue. In terms of the city's plans for staffing the facilities, Raise the Age legislation requires cooperation of SSDs by DOC and ACS, but the legislation does not clearly define the role of each agency within a specialized secure detention facility. The city's plan is that ACS will ultimately be the long-term primary operator of Horizon and will be responsible for the staffing of that facility. In order to prepare for that, ACS has created a Youth Development Specialist title, which is a new civil service title, and is underway in its hiring and recruitment to staff up. That being said, the initial stage of implementation will require phased staffing support from the Department of Corrections, while ACS builds internal capacity. This is in response to the fact that, as I noted earlier, New York City is on a faster timeline for raise the age implementation than any other jurisdiction in the state, and in order to meet this October 1st deadline, that requires this additional supportive staff. The city has prioritized the hiring of youth development specialists, and ACS will begin taking over the staffing and operation of Horizon as soon as possible. We are here before you today with 5 variance applications. These fall within 2 different categories of conflicts. So one, there are BOC minimum standards that directly conflict with a state regulation regarding the same topic. For this category, the state regulation preempts the BOC minimum standard. There are also BOC minimum standards that have no corresponding state regulation. For this latter category, there are several minimum standards that cannot be complied with in the SSD and SJD facilities for a number of reasons, but most prominently related to the physical design and space, as well as differing models between the adult and juvenile justice systems. So I will let the agencies walk through the components of these, but just to frame what we are pursuing are variance applications today for law libraries, a 6-month limited variance request from the minimum standards for telephone calls, variance request related to correspondence, a variance request related to the nursery program, and a variance request as it relates to single occupancy wet cells. So before I'll turn to my agency colleagues who will walk through the specific components of each variances, I did just want to frame that some of the continued issues and considerations that the city is working through and grappling with in its implementation efforts are current restrictions and draft regulations that prohibit the commingling of youth that are the quote-unquote Rikers youth, or the young people who've been on Rikers Island, as well as this gap year 17-year-olds with AOs in housing or common areas. We are still hoping to receive some flexibility from the state for some limited commingling there, but the current draft regulations have that restriction. The law does not have a sunset provision that limits or ends the involvement of DOC in these facilities, so although our plan is to have ACS, as they are able to staff up, staff Horizon, there is not a complete sunset provision by statute on involvement of DOC overall. And then there has been, or there was a lawsuit brought by the unions in terms of the use of correctional officers within Horizon. And the status of that is that the TRO was lifted on June 29th to permit selection, training, and posting of DOC uniform staff in these facilities. We were notified of this on July 5th, and selection and training preparation has begun towards this end. So that is the status of the city's Raise the Age implementation efforts. October 1st is, I think, it's 83 days away, perhaps 84. It is something that we are both excited about, but also very focused on, and requires a tremendous amount of work and coordination amongst all city agencies. It's a great opportunity for the city, but also will require a deep amount of collaboration and work. And I will turn it over to, I believe, Deputy Commissioner Felipe Franco, who will open with a statement on behalf of ACS.
Thank you. Thank you, Dana. Before the Department of Corrections makes their official request, I want to introduce you to ACS. Good morning, members of the board. My name is Felipe Franco. I'm the Deputy Commissioner for the Division of Youth and Family Justice, DYFJ, within the Administration for Children's Services. With me today is Tim Roche, Raise the Age Chief Implementation Officer, Susan Campos, some of you know her, Executive Director of Horizon's Juvenile Center, and Jennifer Romelin, Executive Director for Services at Detention. Thanks for the opportunity to speak to you today about ACS and the Division of Youth and Family Justice, particularly about the youth that will be housed at the Horizon's Juvenile Center. The Division of Youth and Family Justice oversees services and programs for youth at every stage of the juvenile justice process. Our continued continuum includes community-based preventive services and diversion programs for youth who are at risk of delinquency, detention that includes non-secure and secure detention, and soon specialized secure detention. For youth who are arrested and awaiting court resolution. We also provide residential services for all youth placed in the New York City as adjudicated juvenile delinquents, as well as aftercare services upon the return to the community. The Division of Youth and Family Justice was first established in 2010 through the merger of the New York City Department of Juvenile Justice and the Administration of Children's Services. The merger allowed New York City to leverage its expertise in both juvenile justice and child welfare to strengthen outcomes to court-involved youth. A short time later, as some of you know, with the enactment of close to home legislation in 2012, the city and the state ensured that all New York City adjudicated youth were placed in home-like settings close to their families and communities. Now, we have the opportunity to serve 16 and 17-year-olds in a developmentally appropriate detention and placement settings. The passage of Raise the Age 1 year ago means that as of October 1st of this year, newly arrested 16-year-olds will be treated as juveniles and will no longer be prosecuted as adults or held in adult facilities. The same will be true for 17-year-olds starting in October 1st of 2019. Unlike other jurisdictions in New York State, New York City has the additional requirement to transition all currently adult youth charged to 16 and 17-year-olds out of the Rikers Island by October 1st of this year. These youth must be housed in a non-Rikers facility to be jointly administered by ACS and the Department of Corrections. Pursuant to the statute of the OCFS Specialized Secure Detention Regulations, ACS and DOC are planning to share joint responsibility for Horizons for the next 2 years, while ACS develops capacity to serve 16 and older youth and hires and trains additional staff. DOC will provide intermediate staffing support in the facility, and ACS will maintain responsibility for the delivery and coordination of medical, mental health services, case management services, and programming and recreational services. Upon primary responsibility of the facility, transitions to ACS later on. Essential to operating a safe and effective facility is having a unified program approach or a theory of change. To guide all the staff, interactions, and interventions on behalf of youth, ACS has been working for the last 2 years with local and national experts from the Missouri Youth Services Institute, the developers of also Safe Crisis Management, and the team out of NYU Bellevue to develop a wraparound system of care that uses a multidisciplinary team who works together consistently with the same group of youth within a living unit to reinforce positive behaviors, employ a wide range of crisis prevention and de-escalation techniques, and to manage and redirect youth behavior and teach both youth and staff trauma-responsive skills to help youth regulate their emotions and behavior. Central to our work is the belief that the best way to positively influence youth is to strengthen their connections to family and community. We make sure that young people in detention and the staff who works with them remain accessible to families for the entirety of the youth stay with us. As part of Raise the Age, we're making a significant new investments to improve family, youth, and community support within the facilities. Our partners at Bellevue have developed the capacity to conduct family therapy and family workshops for youth and caretakers in secure detention. In partnership with the Department of Probation, we will have parent coaches at each facility. These are parents of youth who have formerly been in the juvenile justice system, who have been trained and can lend their support to parents of youth currently in detention. We began this pilot work at Horizons with Community Connections for Youth, and will continue this work when the facility is jointly run by DOC and ACS. Core to ACS mission is protecting children from harm. We strive to ensure that youth at all Division of Youth and Family Justice facilities and programs have contact with positive adults, family members, and peers, so our staff works collaboratively with parents, guardians, and youth at intake to identify a list of appropriate contact and visitors. Our secure facilities offer visiting hours 4 days a week, including weekdays, evenings, and weekends, and we will increase visiting to 5 days a week by October 1st of 2018. Youth in detention are also able to interact with family during special events at the facility and during the family therapy sessions I mentioned before. Youth in secure facilities now are also able to call their families at a minimum of 1 time per week, and additional phone calls can be earned based on the youth behavior and stage of treatment. When a young person first enters detention, the youth is assigned a case manager. Among the case manager's various responsibilities is developing a parent-guardian approved list of people with whom the youth is authorized to have contact, including phone calls. When a youth is on an authorized phone call, the case manager remains nearby for the duration of the call to de-escalate any conflict that may arise and to ensure that the conversation remains appropriate. These calls are also important and a welcome opportunity for parents and families to engage with the case management. Of course, youth are permitted to contact their attorneys via telephone as often as they need and they request. Unless requested by the youth or attorney, the case manager does not remain in the room when a youth is talking to their attorney. Youth who are pregnant during their stay in secure facilities receive comprehensive medical services 24 hours a day, 7 days a week, including prenatal care and nutritional counseling. With the support of their case manager and an ACS contracted medical staff, these youth are able to remain connected to their family and their co-parents. As part of Race to Age, we're making significant new investments in developing a continuum of flexible wraparound services options for young people who are pregnant or parenting at any moment in the juvenile justice continuum, during their time in detention and beyond. ACS will link youth to organizations that provide targeted wraparound services at the point of the youth admission throughout the release, including nurse-family partnerships and other services that offer individualized parent coaching to assist pregnant and parenting teens in navigating vital services such as medical and prenatal care, lactation consultation, WIC, family planning, employment, early intervention, daycare, educational programs, maternal and child health education, and parenting skill classes. We also leverage services offered for young fathers within the ACS continuum, such as co-parenting skills coaching, which enables youth to gain knowledge and skills to create and implement healthy co-parenting relationships and to reconnect, strengthen, and maintain their parental bonds with their child. Thanks again for the opportunity to speak to you this morning. I now will turn it over to the Department of Corrections.
Good morning. The department is ready to make its first formal request for a variance, and I thought we would start with the first request, which...
I think we're going to take these one at a time.
Yes.
Okay,
I figured we would start with the single room occupancy. So the department is seeking a continuing variance from minimum standard 1-04B2 to allow the Rikers youth and adolescent offender population to be housed in a single occupancy dry cell. That is, cells that do not contain either a toilet or a sink. The department is seeking a variance from section 1-04B2 in part because the physical plant of Horizon cannot accommodate individual wet cells, and this change in design would require extensive reconstruction and additional space that is not available. In addition, the variance is needed so that the incoming adolescent offender population population, and Rikers youth can be housed in a manner more consistent with nationally recognized best practices in juvenile detention, as Raise the Age envisions. It is now, I would turn this over to Deputy Commissioner Franco or Associate Commissioner Tim Roche to talk about the juvenile justice reasons behind this request for a variance. And once the board wants to engage in further discussions about this particular variance, I would then return and seek a variance for the other, make other variance requests for the other items.
I want to have a discussion and a vote on each one separately, though. That
Absolutely.
way we don't kind of confuse.
Very good.
Yeah. Okay.
Thank you.
Good morning. My name is Tim Roach. I am the Chief Implementation Officer for Raise the Age at ACS. I am joined by several of my colleagues here. We look forward to answering your questions and presenting to you on the scope and scale of Raise the Age as it relates to these specific variances. The particular variance that we're considering right now related to wet cells, the Horizon facility is designed as a youth facility. We intend to continue to operate it that way with all of the principles, programming, and physical plant designs that have gone into making it a suitable youth facility. That includes not having toilets and sinks in the rooms, but instead trying to do our best to maintain a home-like environment within the rooms, encouraging young people when appropriate to decorate their rooms in ways that make sense, but not to include toilets and sinks in those rooms. The youth are locked into their rooms during the evening, and during that time there is an electronic indicator that they have access to. They can push a button and it illuminates a blinking red light above the door. Housing unit staff will respond to that room, open the door, and in doing so, the light is deactivated. They escort the youth to the bathroom for use of the bathroom or for a drink of water, and then return them. This has been standing practice, obviously, given the design of the facility, for some time, decades. And this has not been a problem in terms of the speed with which our staff have been able to respond to kids. In surveying staff and youth, it seems that 5 minutes or thereabouts is the approximate outside amount of time that it takes to respond to calls for use of the restroom by kids. Our staff escort kids promptly and return them to their rooms. Given the physical plant, given the mechanisms for alerting staff, the staffing ratios of 6 to 1 on the units, we are asking for the variance as detailed in the formal request.
So,
Yeah.
So the 6 to 1 is in each housing area?
That is correct. That is correct. So in our 15-bed housing units, for instance, there will always be at least 3 housing unit staff.
And when I toured, and I think y'all are doing a great job in putting it all together, when they open the cell, will that time be recorded somewhere? Is that system recorded?
There's an elaborate camera and video monitoring equipment and setup within the facility. One of my colleagues may know actually the number of cameras in each housing unit. I don't off the top, but I know that we've installed literally, there's more than 100 cameras all over the facility. The cameras, I believe, will have direct line of sight that I believe will be able to indicate whether or not that, we'll be able to draw in whether or not that light's illuminated. but some of those cameras aren't installed yet, and that system isn't completely operational. As you, I think, know from having toured the facility, it's still in a state of construction.
But that light system does not record when the light goes on and when it's deactivated with the key. It doesn't.
No, I'm afraid that there is no memory built into that system.
Anyone else? Yeah. So you run three shifts. Is that right?
Correct, yes.
So who will be answering the door? Will it be ACS staff or DOC staff during the evening? It'll be DOC staff. Yeah. So will there be only DOC staff on the unit for the third shift, for the midnight, for the locked-in tour?
Yes, I believe that's correct, yes. On the housing unit.
That's just to start.
Yeah, as I indicated before, as we step up, we ACS will be taking over units at Variances.
Right.
But that will be over the next couple of years.
That is right.
Right. So now it'll be 3, so the department will have 3 staff on the unit at all times during each.
That's the state regulation requirement.
Okay. I would just say that, I mean, even though it is the state of the art, dry cells are historically within corrections a punitive way to treat people. I don't think that was the intent of the Commissioner of Juvenile Justice when Ellen Shaw built Horizon, but it is, and it's not intended punitively, but historically it is punitively.
Yeah, I mean, Dr. Cohen, I mean, if you look at standards on the juvenile justice side, and actually even if you look at the Council of Juvenile Correctional Administrators, like the new white paper in reducing non-confinement, they actually prefer dry cells.
No, I understand. I just always find it hard to think of things that we do right in this country where we've had a history of mass incarceration, locking up 5 times as many people as any other country. So it's hard to look at what we do as being appropriate.
So if there are no other questions, I think we ought to have a vote on this particular variance. Is there a motion?
Motion.
There's also 5 conditions.
Yeah. And do we want to read the conditions?
Rather than make it me all the time.
I'm going to read 5 conditions that were proposed. 1, with respect to youth locked in dry cells, housing unit staff will escort residents of Horizon to the unoccupied housing area bathroom and will provide residents with drinking water within 5 minutes of the request. 2, housing unit staff will document when a bathroom escort or drinking water is requested. Documentation will include the time of the request and the time escorting begins. 3, Horizon staff shall not retaliate against residents who request bathroom access or drinking water. 4, notice of the specific terms and conditions of this variance and the right to notify the board of any related violations shall be provided to Horizon residents. And 5, the department shall provide the board with a monthly audit on its compliance with the implementation of this variance and foregoing conditions. Commencing on November 15th, 2018, the department shall provide its first monthly public audit to the board with respect to the previous month, i.e. October 2018, and within 15 days of the end of each month thereafter.
Right?
Yes, as to, I think most of the conditions seem acceptable to the department. I think on item number 1, the department is okay with item number 1, except that we would ask that we add the language except under absent extenuating circumstances, as we expect to be at full capacity, and with 2 bathrooms, could be 8 or 15 young people. The bathrooms could be occupied at any particular time, so there may be extenuating circumstances that are not something that we can envision at this point in time. So we would propose at least adding that language, but that should, I think, achieve the desired goal of trying to make sure we get someone to the restroom very expeditiously.
Any thoughts at the board level on that?
I would just think that would be something that could be part of the report if you're failing to do it within the time, then explain it rather than us say it's okay not to do it if you can't do it. I mean, just you should be doing it. If you can't, then you'll explain in the report why it's not happening. I didn't understand the relationship of that to not having adequate staffing available initially. You said that there would be not enough.
There are two restrooms available.
Yes.
So if they're occupied and a person is not able to get there within the 5 minutes.
But you'll have the 3 staff there from the beginning.
That's true. But in terms of the minimum standards, we're okay with this. We would just ask that the board consider that absent extenuating circumstances is really something that there are things that you can't envision or know, or something could happen, so that we would hope that we could add that to the first condition.
Is that the only extenuating circumstance you have in mind? Is just
no, I mean there could be there was an incident or a use of force incident or some other issue that would have people out at a certain time, and we're not able to bring people to the restroom on time. There could be a whole host of issues, emergency situations, alarms, fire safety issues. I can't even, there could be a whole host of extenuating circumstances that are probably not routine and not often, but we believe that we need that sort of language added to this first condition.
Any thoughts on that from the board? I mean, the condition currently doesn't contain that, but I just want to know if we should include that or not.
Yeah, I would be fine with that, but there's actually a question that I'd like answered. Do we anticipate that we're going to have lockdowns in Horizon the way we have lockdowns out at Rikers, where sometimes people are locked in their cell for hours at a time and can't get out? Because that would be the only concern that I have. If that's going to be a routine situation, as we find sometimes at Rikers, that means the young people wouldn't be able to get to the bathroom at all.
Again, you know what? We have to abide by the specialized security detention regulations. We actually have to abide by a significant number of reporting requirements to the City Council and the Juvenile Justice Oversight Committee. And among them, anytime that a youth is in a room, besides sleeping, we have to record the amount of time that kid is actually in room confinement, and that will include a group of kids in room confinement.
I'm sorry, I didn't hear that.
So we have to abide by reporting to the City Council. That includes the reporting of the amount of time that a youth is ever in room confinement. So that information is available, and we report it consistently.
But that's just reporting. You could leave them there for hours as long as you report it. Is that what you're saying?
Yeah. I mean, Susan, practice-wise.
So theoretically, no, we really try. It's very difficult not to go to room confinement unless there's extenuating circumstances. And as Commissioner Franco said, we have to record everything. Once a youth has been removed from room confinement, they are also seen by our medical team as well.
Yeah.
So this is an individual youth, not as a policy or not to the whole facility. Is that that's what I'm trying to figure out. There might be a situation involving a particular youth where that person is confined for a long period of time. But I think the question had to do with lockdowns, whether or not you do that.
No. I realize you all might not understand or appreciate what we're talking about. So the Department of Corrections has the authority to lock down. If there's a serious incident, they may not only lock down the housing unit, but the entire facility. But then, of course, the inmates, incarcerated people, have the toilets and sinks in their rooms and their cells, so it's not an issue. Do you all do that thing called lockdown?
It's not a practice within ACS, and nor is it a practice that we anticipate entering into at any point in the future. The other thing is that I believe that a lockdown, as you're describing it, would constitute sort of a mass violation of OCFS regulations around room confinement. It would, in effect, be putting all of the kids in the unit on room confinement, and there are very strict regulations about that, and we have very detailed policies regarding the use of room confinement, limiting that use, and making sure that it can extend for only brief periods, and that there's continued and direct contact and eyes-on supervision. So this is not a standard of practice that is that exists within ACS, nor do we expect to adopt it.
I have a further question. I appreciate that, and I understand that you're committed to an Executive Director Campos as well. Although it is the practice of the Department of Corrections, if there is a fight between two people, to close down a housing area.
That is routine practice. Who will decide whether someone will be placed in room confinement? Who will decide whether or not a housing area will be closed down? Who will decide whether the facility will be closed down? Is that an ACS decision or a DOC decision?
Before we answer that question, I just want to say that the regulations, there are very specific regulations that have been issued by OCFS and SCOC. The department and ACS have been working on making sure we have procedures and directives that follow those regulations. They have to be submitted to OCFS. They have to get approval, and we have to get certification by submitting those approved regulations. So that is what the department is committed to following and will be required to follow and that's our commitment. So.
These will be, facility-wide policies, and they are policies drafted in cooperation with DOC, but based upon juvenile best practices and standards. They're consistent with sort of the practices that we have engaged in and adopted for many years, and they're all being reviewed, commented on, and ultimately approved, not just by our internal hierarchy, including our commissioner, but of course OCFS as well.
Okay. Good.
There's a considerable amount of
those policies. Of course.
So is the board's view that we would include within that the extenuating circumstances exception? Okay, so are we now ready to vote on that? Just with that understanding?
Yes.
Yeah, we're voting on the conditions. Is there a motion on that?
Motion.
Second?
Second.
Sherman?
Yes.
Dr. Sapin?
Yes.
Perino?
Yes.
Richards?
Yes.
Judge Allen?
Yes.
Dr. Cohen?
Yes.
Jones Austin?
Yes.
I'm in favor of that, so that carries.
So reading conditions, but...
Yeah. So now we will vote on the variance with the conditions we just approved, and the variance is for a 6-month period.
To clarify, they didn't ask for 6 months, but the board is treating it.
Yeah, the department, the request was not for a 6-month variance, it was for an unlimited variance, but the department is treating it as a 6-month variance. The board is treating it as a 6-month variance. So now we will, is there a motion for that?
So moved.
Is there a second? Ms. Sherman?
Yes.
Dr. Sapir?
Yes.
Perino?
Yes.
Richards?
Yes.
Judge Handel?
Yes.
Dr. Cohen?
Yes.
Mrs. Jones Austin?
Yes.
And I vote in favor. So that variance carries. Next, we'll hear a presentation with respect to the second variance, which is minimum standard 1-08F, which has to do with the law library.
The department is seeking a continuing variance from minimum standard 1-08F to allow the Rikers youth and adolescent offender population to be housed in facilities that do not have a properly equipped and staffed law library. The department is seeking a variance from section 1-08 in part because the physical plant of Horizon cannot accommodate a full law library. This change in design would require extensive reconstruction and additional space that is not available. I would also now turn it over to the Associate Commissioner to talk about the juvenile justice reasons behind the request for a variance.
So it has certainly been our practice to encourage all forms of education. That is a major emphasis in the work that we do and always has been within our facilities. We operate a school that many of you have seen the physical plant of. We operate it with the Department of Education. And we are proud to say that we graduate kids from high school and they matriculate on in the public school system. We have not not, as a rule, maintained a law library for a couple of reasons, for the physical plant issues, but I think mainly because of the youth of the young people who have been in our system. And we have tried very hard to make sure that kids who were in need of legal guidance were getting that guidance from their attorneys. All of the kids in our system are represented. We extend opportunities pretty much around the clock for legal visits to occur in the facility, as well as make sure that kids are unrestricted from making contact calls to their attorneys. That said, we understand that our system is evolving. It has been evolving for some time, and it is continuing to with Raise the Age. We will be working with a somewhat older population of kids on a longer-term basis, and we see the value and benefit of having legal research capacity within the facility. And what we are proposing is to draw upon the services of Nexus Lexis legal research, having it available to youth on tablets. Although we do not have a law library, we do have a nice library that is a very suitable space for kids to use the tablets with access to Nexus Lexis in order to do whatever sort of research they might need. We are also exploring the hiring of a law library coordinator, in effect. We are looking at having that person available to us on site on a part-time 20-hour-a-week basis. Kids would have access to the tablets for purposes of legal research at least 2 hours a day, 7 days a week. This would be sort of managed through their case manager, but in cooperation with the OE staff as well. We are looking at the possibility of exploring contractual relationships with different entities that might be able to provide the legal coordination services for the youth. We're exploring the possibility of expanding it into perhaps a street law type of program. Things along that line are what we are looking at, but we are committed to having the law library capacity and legal research capacity that we've described.
So I'm most interested in the consultants that you.
Yeah.
I can't help but wonder, how much are these students able to navigate, Lexis as a lawyer myself going years back. I'm a little. I think it's. Yeah. And so it's a nice thing to offer, but I don't think it's really going to get at the issue. Now, the same could hold true with the law library, with law books. So I'm more interested in learning what is your timeline for providing this support that would help young people to navigate these law materials and technology.
Our timeline is all focused very tightly on October 1. This is something that we believe we can have in place as we open the facility and have youth coming into it.
So can you commit to us that you will do that by October 1st?
Given that we have not as yet come up with a clear, sort of identified a clear consultant or the person or persons yet who will serve in that capacity, I would ask for a little flexibility here. Not asking for a great deal of time, but I understanding the city procurement system and the challenges sometimes that one can run into. We want to make sure that we have a little bit of a cushion in the way of time from the October 1st deadline, but this is something that we want to have available as soon as possible.
Right. So I'm just going to push back on you and say that this is not a full-blown program, millions of dollars for a consultant to deliver law support services. So it should be able to be done. And I say this as somebody who's worked for city government. We should be able to achieve that in 3 months.
All right, then.
Let's get it done by October 1st.
We can do it.
And I just to add to that, lot of our kids that you're getting have very serious crimes, and they have to have some kind of access to research, and to have none right now, I think that really takes a tool from them. Even though I do know a lot don't go to the law library, but some do, and not to have that access, and they're facing the rest of their life in jail, serious crimes that they have now. I think, like Jennifer said, have some kind of system in place that we can be comfortable to say, 2 months, 3 months, this is what they're going to have. It's not just they're never going to have it, because if you haven't had it now, it's been running without it. We just don't want to see it continue to run without it.
Yeah, we completely agree. We understand and support the idea.
And I think the 5 conditions that were considered and circulated would ensure that this was implemented as soon as possible and with specificity. Sorry, Stanley.
Yeah, no, just a question. On the request that we got from the commissioner, one of the reasons the juvenile justice system said it doesn't provide law libraries because they don't want young people researching their case. Can you speak to that? Was that an error?
I think that generally
because they hurt themselves?
Well, no, I think that what we would all agree on here is that that young people are prone to making poor, impetuous decisions sometimes, and it is in part for that reason that we have always directed kids to their attorneys for guidance around legal research, around legal decisions, around the implications of their actions involving their cases. And it's just it has been the direction we've always tried to guide kids, understanding that that they're kids.
You wanted to add something?
No, I just wanted to add that we've worked really closely with some of the colleagues here that have testified in our Legal Aid Society to bring in attorneys, not only to discuss the particular cases, but issues that may surround in the facility to help us work with these young people so they understand that their behavior in the facility can ultimately impact their case, as well as understanding what's going on in court. So we worked really closely to establish visiting hours and times, and I often get phone calls on the weekends from attorneys wanting to come in and to make sure that kids have regular access to their attorney.
I'll read the 5 proposed conditions onto the record. 1, Horizon residents will be provided access. Yes.
I think that I want to make clear that what we there's a 25-hour versus a 20.
20. I've corrected.
What we were talking about
20.
Was 20 hours. Thank you.
1, Horizon residents will be provided access to LexisNexis research capacity via tablets upon their request. 2, Horizon residents will be able to access the tablets for at least 2 hours per day, 7 days a week. Access shall be afforded to residents during daytime hours that do not conflict with schooling, programming, counseling, therapy sessions, and other required daily activities. 3, Horizon will have a skilled legal coordinator whose duties will include supporting Horizon residents in meeting their requests for assistance in performing legal research. 4, the legal coordinator will be on site at Horizon at least 5 days per week for a total of 20 hours per week. 5, the department shall provide the board with a monthly audit on its compliance with the implementation of this variance and foregoing conditions. Commencing on November 15th, 2018, the department shall provide its first audit to the board with respect to the previous month, i.e. October 2018, and within 15 days of the end of each month thereafter.
So can I have a motion now to approve the conditions? Is there a second?
Second.
Yeah. Ms. Sherman?
Yes.
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 Thank you. The conditions carry. So now we will have a vote on the variance itself with the conditions we just read, we just approved, understanding again this is a 6-month variance to minimum standard 1-08F. Is there a motion?
Motion.
Second?
Second.
Yes.
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 Variance carries. Thank you. So we're now going to skip out of order a bit to take variance to minimum standard 3-06E5. which is to allow the department to house Rikers youth and adolescent offenders in facility, does not necessarily have child care in a nursery program for women who give birth while in custody. You want to make a...
The department is seeking a continuing variance from minimum standard Section 3-06E5 to allow the Rikers youth and adolescent offender population to be housed in facilities that do not have necessary child care and a nursery program. The department is seeking a variance from Section 3-06E5 in part because the physical plant of Horizon cannot accommodate a nursery. This change in design would require extensive reconstruction and additional space that is not available. Again, I will now turn it over to the Associate Commissioner.
So again, starting with the physical plant, there are limitations there, and this is at least part of the reason that we're asking for this variance. But I think that the real underpinnings for this variance go much deeper than that. It is our interest in making sure that the kids in our care have the very best medical care available to them. And when girls are in our system who are pregnant, we make sure that they have the appropriate medical care, any prenatal care that's necessary. And Jennifer Ronlund can speak in more detail, elaborate perhaps on some of Commissioner Franco's comments about the kinds of services and supports, both medical and related, that we bring in for girls and boys who are parenting. I also think it's important to understand that we believe, we operate a continuum, not just a detention facility, but a continuum of services, including non-secure detention. We have more than 100 non-secure detention beds in small group home settings around the city. Currently, and we work hard to make sure that we are moving kids down in our continuum from secure levels of care to less secure levels of care. It is a constant, it is a constant part of the process that we're engaged in. So, and we've been very successful in doing that. It's part of the reason we have only 36 kids in secure detention in all of New York City today. There are 36 kids in secure detention. And that is in part because of, I think, the quality of the services that we bring, so that kids are staying out of our system, but it's also a factor of our insistence upon moving kids down, stepping them down into lower levels of care. And this is precisely the approach that we would want to use with any young woman who was nearing term on a pregnancy. I think we would all agree that it is very unlikely. However, we understand that the possibility exists, particularly as we're working with some older kids, that a late-term young woman could be placed into one of our secure detention settings. We believe, however, that while we, as the city's child welfare and juvenile justice system, our focus is on the best interest of the kids, making sure that the children, the mothers, the babies, we run mother-child programs across the city for kids in our child welfare system. We have resources upon which we could draw and would, in order to make sure that we were able to design individualized kinds of programming for girls who were in the late term of their pregnancy. We would work very hard with our existing provider network, with the courts, defense attorneys, and with our programming continuum to design individualized plans for a girl who might be in that state, in order to provide whatever security issues might be needed, as well as the medical and long-term care support in doing that in a setting other than the SSD. We would work hard with the court to convince that the ends of public safety could be met through the provision of one-on-one supervision and whatever other elaborate supports were necessary in order to assure the court that we could assure public safety and keep this mother and child together, if that's what was the appropriate thing to do. I'll turn to Jennifer Romlin, who can speak in more detail about sort of the kinds of services that we bring to bear for pregnant girls in our system right now, and the kinds of programming that we could draw on. But as a basic context, our belief is that babies shouldn't be in our detention system. Babies should not be in our detention system, and we would work very, very hard to create individualized settings that are highly appropriate to the needs of the individual mother, the baby, the family, and the court as it relates to public safety in creating some sort of an individualized program outside of an SSD for a girl who is just given birth.
Okay, so we can hear some specifics about that.
Please.
So I think it's important, as Tim mentioned, to state that planning for young pregnant women start when they enter the system. So planning for what is going to happen with that infant, what's going to happen with the mother starts from day one. That includes medical, mental health, and also ultimately for the care of that young mother and the infant. We have had 10 years, I think we've had one infant that was born while the young person was in custody, and that young person was shortly released into a mother-baby program, as Tim mentioned. And we worked diligently with that young person from when she came in up until when she delivered to make sure that we had a plan in place and all of the appropriate parties were contacted, and we were having meetings with the attorney, with the courts, to make sure that that was the most appropriate plan for that young person. Also including programming for that young person so that she is getting parenting skills while in care, and she is learning about what's going to happen postpartum is important as well, and that comes from our medical providers.
So, Martha, do you want to, thank you. Do you want to read the conditions here?
2 conditions. 1, DOC shall submit a written plan to BOC by the October 2018 board meeting. That will include a description of the wraparound model of support services ACS shall offer to pregnant youth and to all young mothers and fathers residing in Horizon, the service providers who shall provide such support services, and the timeline for procurement of such services. 2, DOC shall notify the board in writing of each admission of a pregnant youth to a facility within 3 business days of such admission, and such notification shall include a description of the steps to be taken to seek her transfer to a facility where she can reside with her child.
Go.
I have a few comments, and I'm sorry this variance was proposed to us. I would have much preferred to hear your program rather than for us to ask for the program. I mean, you just said we don't want to. I mean, what the department asked us was to just not provide not say what's going to happen for a woman who delivers. A young woman who delivers in the system. And then for us to now say you're going to give us a program by October doesn't seem right to me. I think much better would be to come back in September with what your program is going to be. Specifically, when you're going to go to the court, what other possibilities you have, how you're going to guarantee that no matter what, a woman and their child are not, a mother and their child are not separated. And I just have to add, that I mean over time, ACS has been problematic in this issue from the department, from the Board of Corrections perspective, or from my perspective, even when I wasn't on the board, which is that you are the organization that prevents women from boarding with their children substantially on Rikers Island. Not you, but you, ACS does that, and I've never understood it exactly. That's my failure. But I mean, what better situation could you have than having full-time social work staff and nurse all the time, to have a mother and their child together on Rikers Island, yet consistently one of the major reasons for not allowing boarding of babies and their mothers was an ACS hold on the project. So I would really like you to come back to us. I'm sorry to come back to us, tell us what you're going to do to assure that that young women who deliver are kept with their children, rather than ask for a variance saying we don't have to provide that service.
So if I may just add to the record, I appreciate the points that you're making. Bobby, but I do think it is important to know that ACS through the years has worked to develop programs to keep foster mothers, teenage mothers, with their children in maternity shelters or in foster boarding homes. If they were in foster care homes, they would try to keep them with the child, with the mother in the foster home. So I do think that needs to be noted, that there have been many efforts and productive efforts in that regard.
I mean, I certainly can't speak to ACS's practices relative to women on Rikers Island, but at least as part of the juvenile justice system and as part, I ran the children's center at ACS for a couple of years, and I know that we make every effort with the young women in our system to keep them connected to their babies whenever that is possible, and it is certainly our intention to continue to do so within the context of this system.
I'm sure you will. I just think what you asked for should say that.
So I just wanted to say, echoing what Jennifer's saying, as a family court judge here for 10 years, it was my experience that ACS did a fabulous job with the young mothers that found themselves in foster care to try to find mother-child programs so that they could stay together in foster care. So I trust that you really will do your very best. I think the Children's Defense Fund had proposed a condition in their papers that they really weren't opposing this as long as there was a condition being that there be appropriate facilities located outside SSD for parenting and pregnant mothers. And that way that allows you, because I certainly would support this, especially with that condition, which I think is very reasonable. You seem to be in agreement with, and I trust you all will truly do that. Yeah.
Should we vote on the condition now?
Yeah, so I need to propose this. Does anybody have Children's Defense Fund papers that state the specificity of the condition? Otherwise, it was something to the effect that the condition that appropriate facilities be located outside of this specialized secure detention for parenting and pregnant girls. So there's no reason to have the nursery, but they locate other facilities. Let's see what it is.
It's the last paragraph.
So I just want to read for the entire board in case you don't have your papers, which I didn't have, which is that Children's Defense Fund was recommending we not improve it unless we add a condition, which is a condition I would be proposing that requires the Department of Correction and the Administration for Children's Services to ensure that the agencies maintain appropriate placements outside of specialized secure detention for pregnant and parenting girls where these youth could be placed without being separated from their children. So is there any objection to that condition by the department or ACS? No? No objection. Okay, so I would move that that condition be added.
Okay, so we now have three conditions. Yeah.
Well, I'd like to add one more, that the ACS explained to the board in those cases when it rules that the mother and child should be separated, which it's done repetitively over the past 35 years for women on Rikers Island. You're asked that by the Department of Correction, and you routinely, not all the time, say, no, this mother should not be allowed to board with her child. So that there be an explanation provided for us why ACS feels that way if they do.
Now, you know that relates to Rikers and not Horizon.
Well,
That's not related to this.
What?
You don't think that's covered in the description of such notification shall include a description of the steps to be taken to seek her transfer to a facility where she can reside with her child? Do you want to modify that?
Okay, do you think that covers that? Yes, okay.
This is just for Horizon. This is not for the nursery.
No, I understand. I'm just concerned about the same decisions being made.
Well, they'd have it right there.
So will you withdraw that?
Yes. Yeah.
Okay, so we have the three that we've read. We'll take a vote on those first. Is there a motion?
Motion.
Is there a second? Second. Sherman?
Yes.
Caterina?
No, I'm not going to support this one, only because I've seen the importance of kids and their mothers and how staff engages, and I think it's really important and I'm just not happy with, we don't have the space or the structure. So at this juncture, I'm going to say no.
Yes.
Yes.
Yeah, I'm going to vote no, and I think we really should have a more detailed plan about what you're going to do.
Yes.
Yes. And now we vote for variance itself, that is the minimum standard 3-06E5 with the conditions we just read. Is there a motion for that? Still on a second. Okay, Ms. Sherman.
Yes.
No.
Yes.
Yes.
No.
Yes.
Yes. Okay, thank you. That again is a 6-month variance. We go back to minimum standard 1-11 correspondence.
The department is seeking a continuing variance from minimum standard section 1-11A to allow for a modified model of correspondence for adolescent offenders and Rikers youth that more closely aligns with ACS's existing juvenile detention model. Under this system, there would generally be no restriction on either the amount of correspondence youth receive or on the language used by youth in the correspondence. However, procedures will exist for identifying individuals for whom mail correspondence is prohibited or restricted based on the safety and security of the youth, the facility, and or consistent with any existing court orders. I will now refer any questions to Associate Commissioner Roche.
Again, the young people in our care are young people, and it is our obligation to look out for their best interest. And with that sort of overarching objective in mind, we limit contact that kids can have with certain individuals by creating an approved contact list. This is a list that is created with the youth's parent or guardian, along with the youth and their case manager. This is a practice that we have engaged in for some time for the purpose really of protecting the kids. There certainly are individuals out there with whom kids might either be contacted or choose to engage who mean them harm. And we believe that it is our job and responsibility to prevent that, and it is for that purpose that we create an approved contact list. This is by regulation of OCFS. It has to be revisited at least every 3 months. It is a dynamic process. It is one that is engaged with the parent and guardian, the youth, and the case manager. Opportunities exist for the young person to offer his or her opinion and the rationale, and we do our best to hear kids on these things. But that is the basis for our variance request.
Any questions or comments here? Yeah, go ahead.
I think this is much too vague. I think our current board standard on this is appropriate. I don't think the board should approve a variance which limits who someone can write to. I mean, we have a standard that says if there's communication going on which is dangerous to the facility, then that should not be allowed. But that's not the issue here. Here is you're prescribing who the person can write to and receive communications from, and I don't think that's consistent with the way with how these young people should be treated. They should be able to write. They should be able to communicate with their family or friends if they want to without your pre-approval. So I think the board should vote no on this one. If you want to come back to us with something that describes what you're doing in some more detail, so I understand it, but it's very vague. You can do it for whatever reason you want right now, and that's not something we should be supporting.
Can you describe the process? Like, how does this?
Yeah, and how it's worked in the past.
Yeah.
I mean, we can certainly describe the process. Bear in mind that there's really no limit to who the kids can contact, with the exception of the fact that there may be individuals who we would prohibit contact with. So the list could be sort of unlimited in terms of its length, but the idea is to make sure that we are able to identify those people who we want to prohibit kids from having contact with. And so that's the basis of what we're trying to get at.
And as they are young people, when they enter the facility, the case manager meets with that young person and then calls or meets with their parents. And their parents know who that young person should be associating with, who is negative in their life, who is a positive influence in their life, and that list is generated in conjunction with the kid and the parent. And again, as Tim mentioned, we have to revisit that list every 3 months. And again, it could be 20 people that are on the list. It could be 5. It could be 2. The parent could call back later and say, I noticed that Johnny is not a good influence now that I found out whatever information. I don't want him on that list. So it's really to ensure that kids are speaking with people that have their best interests at heart.
And I think it's important to keep in mind that besides being regulatory mandate of OCFS, it actually comes out of OCFS experience of having have young people in their facilities be victimized and targeted by bad elements. I mean, it's sad to admit, but actually there's a lot of folks that actually will take advantage of our youth if they know that they actually are vulnerable, and that actually has happened in the state of New York, and that's the reason behind some of the regulations. And we want to make sure that, there's a lot, I mean, as Tim mentioned before, we have done really well about keeping most of the kids out of detention. We only have 4 girls in detention today in New York City. We are committed to actually have none of them eventually, but boys and girls can be seriously victimized, and there's a lot of predatory elements out there.
I'd like to just speak to this. I am aware that this is the juvenile justice model, and of course the reason we have to raise the age is because, the legislature, the governor, and many, many advocates in this room and out that have worked very hard to transfer these young people, 16 and 17, that have been treated in the adult system, to have them transferred so that they are treated in the juvenile justice system. So that does mean that we are going to have some changes, and I do credit, I'm very well aware that many attorneys who represent young people want to have limits placed on them for their own benefit. So I do fully support this variance. I think it's in the best interest of the children who will be coming into your care and custody.
So are we ready to take a vote on this? Is there a motion?
Yes.
A second? Second. Sherman?
Yes.
Reno?
Yes.
Richard?
Yes.
Yes.
No.
Yes.
Thank you. Motion carries. So we have now a variance. Again, that's a 6-month variance. We have variance DOC standard 1-10, which has to do with telephone calls.
The department is seeking a 6-month limited variance from minimum standard section 1-10 C F H I to allow for phasing in 1 call per day for youth. ACS is attempting, the department's been informed that ACS is attempting to procure an automated phone system that would allow for daily calls. Until then, ACS proposes a modified model for this system, modified model for telephone calls for adolescent offenders and Rikers youth that aligns with ACS's existing juvenile detention model. Under this system, all youth would be allowed a minimum of 3 7-minute phone calls per week until the automated system is available. The frequency and duration of additional discretionary phone calls would be directly tied to positive behavior management system. With positive behavior comes discretionary phone calls. All calls are facilitated by ACS case managers and are conducted in their presence. I'll let Tim Roche address any questions.
Yeah, I just have a quick question. So there's the The 3 7-minute calls per week, that's a total. Does that also include calls made to the attorneys?
No.
Or is that excluded?
No, absolutely not. And I would also add that our mental health team, which Commissioner Franco described as being a very robust team driven by the Bellevue NYU mental health staff, often encourages and facilitates the contacts with the family of youth and engages in telephone conversations, and all of those happen with some regularity, and those would of course be in addition to these calls as well.
So what happens if you, is it 3 attempts per, I mean, what happens if you make a call and a person's not home? Does that count as one of the calls or no?
No.
That does not?
No.
Okay, and...
I mean, it's a real phone call.
Real phone call.
I mean, we you know, as I think that all of what we have tried to convey here today goes to is that we are a system that values family engagement, that tries hard to create opportunities for kids to be connected and to remain connected to their families.
Is there any limit on the number of calls you can make to an attorney?
No.
No limit?
No limit. No limit.
And that's not included in the 3 phone calls.
And not included in the 3, right.
It's not part of that.
Okay.
And I think that in the materials that were submitted, it was described, the case management. I should let Jennifer, why don't you describe the way the calls are conducted and arranged and facilitated by the case manager.
So currently, the case manager brings the young person in the office. She brings up the young person's case record and their approved lists. They want to call Johnny. The case manager will dial the phone number for Johnny, ask for Johnny on the phone, and then hand the phone to that young person to have that conversation to ensure that that is in fact who the young person is speaking to. And that practice will remain until the automated phone system is implemented and we're ready to go with that. So these 3 phone calls will include that. But I will add that outside, if a young person is struggling or having issues, we do bring the young person into the case management office as well. And if he or she needs to call mom or dad or grandma or grandpa, that phone call will be given, and it's not included in that 3 phone calls. Absolutely.
A question I have around the automated system. When I did the tour, I understood that this new automated system will be similar. It might not be the system that the Department of Corrections is using, but it might be similar in that it will record the calls. And that is not something that ACS is currently doing. So are y'all adopting that practice?
So we will have the ability to either turn that feature on or off, and we haven't determined whether or not that is going to be, we are going to be recording phone calls, but that vendor we don't have to have that capability.
Okay.
The reality is that this automated system has a lot of features that will be very helpful. You know, we can time the calls, we can pre-program, we can be alerted if a 3-way call is initiated, and the recording of calls is also an option. We have not, as a practice, ever been involved in the recording of conversations with kids. We want to reserve the right to, in some instances, perhaps it might make sense, but that is not a practice that we will engage in as a matter of course. But certainly the automated system will have that capacity.
I'd like to figure out some way, maybe not in this process, some way of making sure we're talking to each other about what options you end up using and why, just to make sure. I really wouldn't want to see y'all pick up a practice that y'all are not doing, that DOC is doing for reasons that they need to do, but you have not done, and you shouldn't probably be doing.
So I appreciate that, and as I said, you know, we intend to continue to operate a juvenile justice system, and I think that you know, there are many challenges that we will encounter as we have along the way, and I'm sure that, you know, we will benefit from the insight from the board as well as from our DOC partners and the other advocates in the room and everyone else. I mean, we have benefited greatly thus far in the design of this system. We are very mission driven and determined to keep a juvenile justice system, the New York City juvenile justice system, on the trajectory it's on, which is that of a national model, and we intend to continue.
So if you record the kids' telephone calls, would you inform them beforehand that that's the practice?
This isn't a decision that we have made. I imagine that it makes sense that we let kids know that the phone system that they're using has the capacity to record a call.
No, I'm not asking about the capacity, though. I'm asking whether or not the kid would be informed that the
Can I buy some time on that one?
Just let us know. Whatever you decide. I mean, following up from Stanley's question, let us know how that decision comes out. But I would be interested in that particular question.
I understand the strategy with the correspondence, but what's the strategy with only 3 days a week, a kid not being able to talk to his family?
We want to move to daily. Once we have that automated system, we can move to daily call. Given the process that Jennifer described, we've got one call, each housing unit has a case manager office, and a telephone in that office. And so the process of facilitating those calls is labor intensive. And but once we have these automated systems, we will have 3 phones on each 15-bed housing unit. It'll allow us to go to daily phone calls and do so without sort of running into sort of the challenges we do now.
And offer more calls. I think you said, and I've seen where if a young person is stressing out and a call to his mother will reduce that stress, you'll make that call. Yeah.
It's in our interest to facilitate those calls.
I don't think this is a variance that the board should pass for similar reasons to the correspondence variance. Your policy, I understand you've changed your policy since I visited the facility. At that point, your position was three a week is a good idea, and it allows us to give additional phone calls as an incentive. The policy is now changed, as I understand it. Your goal is to, in compliance with board policies, to allow a phone call every day. But you are limiting who people can call, which I don't think you should do. I don't think we should give your staff the right to decide who someone can call. And I'm gonna, and it's a shame that so far into this process that we talked earlier before the meeting, and you described a process of about 7 months more it's going to take before you get the phone system in place. That's the numbers you gave. You gave me 90 days and then 120 days on top of that. So it's going to be another 7 months where people are only going to get three phone calls to 3 phone calls a week.
Before they come into the system.
Excuse me?
I mean, nobody's coming in until October 1st. So.
Okay, so it'll be another 4 months. Sorry, and I don't think the Board of Corrections should agree to a policy that restricts who 16 and 17-year-olds can call. So I'm going to recommend that the board does not approve this. I mean, you're going to be in a situation where you're, for a time, if we don't approve the variance, that you'll be in violation of our variance because you'll only be providing three phone calls, but our punishments are.
Dr. Cohen, I just wanted to remind you that with respect to the list,
yes,
that is required by regulation, by OCFS regulation. We have to do that. So anyway, I just wanted to restate that.
Okay, that's the case.
So are we ready to vote on this? Martha's going to read the conditions.
There were 5 conditions considered by the board. 1, DOC shall submit a written plan to the board that includes A, detailed description of the telephone call model DOC proposes to use pending implementation of an automated phone system at Horizon, and B, a plan and timeline for implementation of the automated system. 2, the department shall submit its written plan to the board by September 7th, 2018. 3, all Horizon youth shall be allowed a minimum of 6, did we clarify 7 versus 6? You wrote 6. It says 7. It says 7 in the. It says 7 in the variance request, so we had 7 in this condition. A minimum of 3 7-minute calls per week until the automated phone system is available. 4, upon implementation of the automated phone system, all youth shall be allowed a minimum of 1 7-minute phone call per day. 5, all telephone calls will be at the expense of the facility. Can we... I'm just trying to get clarity on the 7 versus 6. I don't know why 7.
7 minutes is fine.
Thank you.
I think the 6 came from the board stand.
Right, okay, so it includes 7 as the conditions I read, and that you read here. So those were 5 conditions.
So we will now take a motion to approve the second. A second? Yeah. Mr. Chairman?
Yes.
Reno? Yes. Yeah, Judge?
Yes.
Yes.
Thank you. So now we vote on the variance itself with the conditions as just read. This is a 6-month variance to minimum standard 1-10 telephone calls. Is there a motion? Is there a second?
Second.
Sherman?
Yes.
Reno?
Yes.
Yes.
No, and I wish the department had provided what we asked for before we had to go to this thing. That would have been a much better way to do it, but no.
I vote in favor. Okay, that carries. Thank you. We are now have finished our voting on the various variances, and we have public comment. We have 2 people who would like to make a public comment. The first is Vidal Guzman.
Hey, how you doing? Everyone can hear me? My name is Vidal Guzman. I am the community organizer for the Closed Rikers campaign. I think a couple things I have to first say. I'm formerly incarcerated, did 7 years, and I used to be a high-ranking member of the Bloods. So I definitely have conversations. I know a lot of people are not really know about a lot of this stuff. But one of the things that really came to mind, we should let 19 to 21-year-old come together with the older crowd. As a person that was incarcerated with individuals that was 19, one of the things that I learned is that you are not, as we all know, individuals are still learning. 16 to 24, their mind is actually still growing. We have to not let that happen. One of the reasons why we say that is because as a person that was incarcerated at 16, when I came home at 18 on probation and I got reincarcerated again at 19, one of the things that I learned is jail and prison prepare you to go in and never prepare you to come out. So at 19 years old, I actually got incarcerated again. But I seen the same people that was incarcerated at 16 go back at 19. So to actually put these individuals with the older crowd is a no-no. I think the second thing too is we know repeatedly that the DOC does not have the proper training to de-escalate violence. We lost a 27-year-old man yesterday to in an AMKC, a facility in Rikers Island, where individuals are being housed in a unit for mental health issues that have been determined but not have been serious disorders. So, as we know, as yesterday, a lot of us heard about an individual that, passed away, but we know that person is dealing with mental illness issues. The time is overdue for the country to actually understand, and especially New York City, that we can't jail our way out of health problems like mental illness. And I think another thing about it is the telephone call about having 7 minutes or having individuals call their family 3 times a week. One call for a youth is belittling and inhuman. The importance of a phone call for a youth at 16 years old is the bridge that's created for them to never come back to jail. A phone call is the closest connection to their family if it isn't a visit that day. And I say that repeatedly. If a person cannot see their family member and they can't talk to them that day, that is not a solution to a family member that has a person detained in that facility. I'll be done right now. I think one of the most important things as a person that was 16 and I spoke to, and the reason why I speak on this so much is because I do facilities where I do a workshop with youth all around 5 boroughs with individuals who are coming home. And one of the things that they say while I was in there, what was the most important thing while you was detained that you got the most of? It says actually talking to my family every single day to return me back to society, to actually train me and say, hey, this is what you need to do. I'm not trying to take too much. I know definitely we have an, and I think it's also most important too, we also need to understand the report back, knowing that there isn't going to be no toilets or sinks in that facility. We need to know repeatedly what's actually happening. If something's actually happened, as a person that was incarcerated at 16, I said before, I've seen places where the place is locked down and a correctional officer over-abused their power and not let a person use the bathroom. And when that happened, when that happened, that individual that he said he can't use the bathroom, what that person actually did, went to the corner of the cell and started pissing. So like I said before, this is most important to us, is this call, understanding that we have to have the process of an individual call their family every single day. All right, yeah, I'm gonna be finished right now. And the second thing about it is not limit who they're calling. Thank you.
Thank you. And the last speaker is Al Craig.
What is it, morning, evening? I think it's evening. Wow. I just want to say this. It's amazing to me that for 3 years I've come here and I've heard you bash us. Oh, we abuse inmates. We aggressive. We do all of this stuff. And now we the savers of the youth. Boy, I don't know how that happened, that we were abusing them on Rikers Island. Now we're being told to go to some juvenile facilities because we're the best equipped. That's the mayor's line and his people's line. It's a joke. It's a real joke, and it's so insulting. You know, I don't know. You know what's really the hypocrisy with a lot of these advocacy groups and a lot of people is that they say when they're dealing with police that you need more minorities. Guess who got minorities? Corrections. You say we should use, when somebody gets shot, why they didn't use OC? We use OC, and then we get you up here talking about it's abuse of OC. Use the very minimum force, we do it, and now, see, that's because you don't know a damn thing about what you're talking about. It's amazing. The rest of the country is protesting everywhere. Everywhere they protest because for these things, and you have them in the Department of Correction, and then you sit up here and you say, well, you know, don't do what the rest of society is calling for, protesting for, wearing black like you did, a Black Lives Matter t-shirt. But we have them here, and you are still not happy. That means you can never be happy. You're never going to be happy because you don't know what you're talking about. See, it's amazing to me that we come here every freaking month and we hear all of this nonsense. It's utter nonsense. And you've never addressed safety. You know, thousands of people have gotten hurt since many of you people have sat here. And since many of you have been in your positions, and you've done absolutely nothing. You haven't done a damn thing about it. And I've come up here, if somebody came up here for 3 straight years and said the same thing, it's the same thing. We need to make it safe. We need to make it safe. I've screamed, I've yelled, I've met you, I've done all kinds of shit except circus tricks to get you to listen about safety. Now what you guys don't understand is now the same kind of crimes they're committing on Rikers Island, they're doing in the streets. They're not carrying guns, they're carrying machetes and razors and knives. See, because the sagging that everybody gets upset with the young people, they're doing that, they started it in jail. Now went to the streets. Because you failed to do something about crime on Rikers Island, now the same kind of crimes are happening in the street. And I'm going to tell you why nothing is getting done. What's in common? You have a mayor that let black and Latino kids get lead poison. You have a mayor that have black and Latino officers and inmates get hurt. He does nothing. He does nothing but lip service about this. You people have the power, and you people have the power, and I'm so frustrated after 3 years of coming here going, safety, we got to make everybody safe. We got to make everybody safe. And like I said, we use the least amount that the whole nation is screaming about. Correctional officers use that every day to stop things from happening. And you don't seem to get it. That's because you are bought and paid for. Like Mr. Safia told me in a meeting, being that we all talk about things, he said, I'm not going to do anything to go against Mayor de Blasio publicly. That's what he said. So I understand, it's not him, it's Mayor de Blasio that's doing this, that wants a less restrictive jail. I don't know what that means, but now it's trickling out to the streets. Everybody's upset about that young man getting stabbed. That's a jail crime. The viciousness that he was attacked, it's a jail crime. And that's what happens all the damn time to people in jail, and you got the power to do something about it, and you won't. So why don't you do everybody a favor? Stop being a hypocrite. Come up here and have Bill de Blasio sit here, have him sit here, and let him put on this artful dance that he does, because it doesn't make sense. And one last thing, the reason why he's doing it, it took me a minute to really understand it, why he wants a less restrictive, why people are now, 20 people got shot a couple of Saturdays ago. This is real seriousness. People are getting hurt and you're sitting here doing nothing about it. Nothing. Not a damn thing you do about it. And this is ridiculous.
Craig, you run out of time.
Yeah, I know, but I've been sitting here for three years saying this. I'm hoping one time that you'll sit there and go, wait a minute. Does it not look similar what happened to that young man in the Bronx that happens on Rikers Island? We ought to do something. You know why they're carrying these weapons? Because the gun laws are so harsh in New York City. Now it's about carrying knives that are not considered weapons, but are considered dangerous instruments. And you people got the opportunity to do something, but you're not. So, I mean, this might be the last time you see me up here, and I may be mad to make you a little happy. So I'm going to go to the State Commissioner of Corrections and start screaming and yelling, and then I'm going to sue them, and then we'll have the court again with them, then I'm going to sue them again, and I'm going to drop lawsuits, then I'm going to drop newspapers ads, and I'm going to do every damn thing, and it means protesting outside of your houses. You people are going to do something. You're going to have to say, sit on the toilet or whatever that is, or get off, or whatever the saying goes. You're going to do something. Thank you very much.
Thank you, Mr. Craig. That's the last of our public speakers, and I think we can adjourn the meeting now. We'll see you back here. And there's no August meeting, so it's September 11th. Thank you.